Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. Introduction to Paralegalism. Perspectives, Problems, and Skills. 9th edition. Chapter 8. Narrated by Omar Mohsen Ibrahim Fouad. Introduction to Legal Analysis. Chapter Introduction. Chapter Objectives. After completing this chapter, you should be able to define legal analysis. List some of the major skills involved in legal analysis. Illustrate how to break a rule into its elements and why this is important. Demonstrate how to spot and phrase issues. Explain the importance of definitions and know how to phrase them broadly and narrowly. Distinguish between element analysis and factor analysis. Analyze the distinctions between IRAC and IFRAC. Give examples of the components of an opinion. Write a comprehensive and a thumbnail brief of an opinion. Justify why an opinion applies to a particular set of facts. Create a memorandum of law with supporting legal resources. What if one of the firm's biggest clients is scheduled for a meeting later in the day? The client is the new owner of a refinery on a remote island off the coast of Texas. All that you know about the case is that the refinery was dormant for years and the client is in the process of restarting the operations. The Environmental Protection Agency, EPA, gave the go-ahead to begin the process of startup. While the company was investing tens of millions in the refinery by updating and replacing machinery, hiring personnel, and testing equipment, there was a change in policy within the EPA regarding permitting. The EPA sent the client a letter stating that they needed a new permit, as their position now was that the refinery was not a restart, but considered a new operation, requiring new costly permit. From what you understand, the issue is a definition of restart, as well as the change in position of the EPA requiring the new permit. The legal team is being asked to analyze 1. The definition of restart, and 2. The actions of the EPA in changing its position on the need for a new permit after the client invested tens of millions of dollars. The refinery is in danger of never restarting its operations because of the extraordinary expenses related to applying for the new permit and its subsequent requirements for the restart. You have been asked to prepare a memorandum of law on the several issues that may arise from the letter the client received from the EPA, including whether, under the Clean Air Act, the actions of the refinery are considered construction. requiring a new permit. As a paralegal, you will be involved in assisting with the analysis of many client issues. Some will be straightforward, while others will be more complex. Knowing where to begin the process and how to identify the elements of the problem presented is an important step in analyzing a client's problem. This chapter will focus on the analysis that should be performed when presented with a legal problem. What steps should be taken along with spotting the issues involved is part of the focus of this chapter. Learning how to analyze and review a case and applying the case reasoning and law also will be introduced in this chapter, resulting in the preparation of a memorandum of law. Later chapters will examine the skills of legal research and writing. In this chapter, you will begin crafting the issues as you prepare to commence the research and writing stages after you have analyzed some of the general concepts that are involved in the case at hand. 8-1 Legal Analysis Skills Introduction. Legal questions are answered by applying rules to facts. The application is called legal analysis. The interrelated goals of legal analysis are as follows. To avoid a legal dispute, like for example, will I get into trouble with the Federal Trade Commission if we merge with our main competitor? To resolve a legal dispute that has already arisen, like for example, I feel the deduction I took was legitimate, but the IRS has notified me that I now owe interest and penalties because of it. To prevent a legal dispute from becoming worse, like for example, the police are on the way to question me about the fight I was in. What should I tell them? Paralegals need to study legal analysis for two main reasons. First, many paralegals are given assignments that in varying degrees call for legal analysis. Secondly, and perhaps more importantly, attorneys talk the language of legal analysis all the time. Issues, rules, exceptions, elements, briefing, reasoning, etc. A paralegal who knows the basics of legal analysis will be better equipped to understand and communicate with attorneys. 8-1A Legal Analysis Skills. Competent legal analysis may involve a number of basic skills. Legal research. This skill allows you to find rules that you need to apply to the facts of a client's case. Legal analysis and legal research often occur simultaneously in the sense that preliminary legal analysis helps the researcher decide what laws should be checked. Element identification. Once you have found a potentially applicable rule, the skill of element identification allows you to break any rule into its essential parts, elements, as a first step in identifying issues. Identifying issues, issue spotting. This skill allows you to identify which elements of a rule are in contention. Each element in contention will be the basis of a separate issue. Phrasing issues. This skill allows you to phrase issues comprehensively and in shorthand. Defining important language. This skill allows you to define important language in the element in contention using available court opinions, if any, that have interpreted and defined the language. Applying definitions. This skill allows you to apply the definitions to the facts, again, using available court opinions, if any. Factor analysis. This skill allows you to apply a rule when it contains factors. Briefing court opinions. This skill allows you to understand a court opinion in order to assess whether it might apply. Applying court opinions. This skill allows you to apply a court opinion to your facts. The sequence of using these skills that we will examine in this chapter is outlined in Exhibit 8-1. Find a rule, break the rule into its elements, identify the element in contentions, phrase an issue based on the facts and the element in contention, define important language in the element in contention using available court options, if any. Apply the definition to the facts using available court opinions, if any. Exhibit 8-1, skills involved in legal analysis. 8-1B, finding a rule to apply legal research. The first task is to find a rule that might apply to the facts of the client's case. The law firm may already be aware of potentially applicable rules because of its prior experience with other clients and the nature of its practice. If not, it must find those rules through the skill of legal research, because the law is constantly changing. Legal research is also needed on an ongoing basis to determine the current validity of any rule the law firm is considering. We will cover the skill of legal research in Chapter 9. Here in Chapter 8, we will assume that one or more rules have been identified. In this chapter, the word rule means any primary authority, which we defined in Chapter 7. Secondary authority means non-laws, non-rules, and we will define this in Chapter 9. The most frequently applied primary authorities, rules, in legal analysis are statutes, administrative regulations, common law rules, constitutional provisions. In Chapter 7, we also defined common law as judge-made law in the absence of controlling statutory law or other higher law. The phrase common law rule refers to any law that was created by the courts that was judge-made. When someone is sued for a violation of one of these rules, the theory of the suit is called a cause of action. The cause of action becomes the rule that the person is alleged to have violated. Although the phrase cause of action is most often used in civil cases, it can also be used in criminal cases, as we will see. 8-2 Legal Analysis Skills. Element identification. Once you have a rule that might apply, the analysis begins by breaking the rule into its basic parts. We call these parts elements. An element is simply one of the parts of a rule that must apply in order for the rule to apply. An element is, therefore, a precondition of the applicability of the entire rule. The element identification skill requires you to answer two questions. What is the express or implied consequence of the rule? What must happen before this consequence will be imposed or go into effect? When you answer the second question, you will have identified the elements of the rule. Every rule has a consequence or an effect if the rule applies. These consequences can vary. For example, there are rules that authorize something, prohibit something, impose punishments, require payments, establish a right to sue and receive damages, require safety steps to be taken, institute procedures, make statements of policy, declare definitions of important concepts, carry out a combination of the above consequences. The consequence might be stated in the rule or it might be applied. Implied. After we look at some examples, we will summarize the guidelines for the element identification skill in the next section. We begin with some relatively simple rules. 8-2A Examples. Example number 1. Co-op. Rule Statute 10. Any business operating within the city must obtain a commercial license. If Statute 10 applies, a commercial license must be obtained. This is the consequence of the rule if it applies. To find the elements of Statute 10, make a numbered list of its essential parts. Elements of Statute 10. 1. Any business. 2. Operating within the city. Note that the list uses the exact language of the rule and that the consequence of the applicability of the rule, obtaining a commercial license, is not listed as one of the elements. To list the consequence of the rule as an element would be circular. It makes no sense to say that one of the preconditions of having a license is to have a license. In some issue statements, you may want to include part of the consequence within an element in order to clarify the context of the element. This, however, should be rare. If you do include the consequence, be sure that you avoid circular reasoning when you apply the element. Element identification is done in your head, on a scrap piece of paper or notes in your computer. It is not handed in to anyone. It is one of the preliminary tasks of legal analysis. Example number 2. Bike on road. Rule Statute 92b. The operator of any vehicle riding on a sidewalk shall be fined $100. If Statute 92b applies, a $100 fine will be imposed. This is the consequence of the rule. Here are the elements of the rule. Elements of Statute 92b. 1. Operator. 2. Any vehicle. 3. Riding. 4. On a sidewalk. Example 3. Pharmacy. Rule. Statute 25-403. A pharmacist must not sell prescription drugs to a minor. The effect or consequence of this rule is that something is prohibited. The selling of prescription drugs. For any rule, ask yourself what conditions must exist before the rule applies. Your answer will consist of its elements. Elements of Statute 25-403. 1. Pharmacist. 2. Sell. 3. Prescription drugs. 4. To a minor. The second element does not say must not sell. The must not language is part of the consequence. If the elements apply, then the must not command kicks in. Example number 4. Additional punishment. Rule. Statute 109. A judge may impose additional punishment when a weapon is used by the accused in the commission of a drug offense. Often, there is more than one way to list elements. Here, for example, are 2 ways to phrase the elements of Statute 109. Version A. Elements of Statute 109. 1. Judge. 2. Weapon. 3. Is used in the commission of a drug offense. 4. By the accused. Version B. 1. Judge. 2. Weapon. 3. Is used. 4. In the commission of a drug offense. 5. By the accused. The consequence of Statute 109 is that a judge can impose additional punishment. In version A, note that there are 2 themes in the 4th element: use and commission. By combining them in one element, the verb used is seen in perspective. The element focuses on the what the use involves. Nevertheless, it is possible to separate these concepts into their own elements, as seen in version B. How do you decide which versions to use? The facts will usually suggest what is needed. Suppose the accused merely had the weapon, like for example a loaded gun, in their pocket at the time the drug offense was committed. The question would then become whether possession could constitute use under Statute 109. The facts would prompt you to discuss used separately. Either version, however, would work. If you used the first version, you would simply have to focus on one piece of the 3rd element, used. The main guideline is to be narrow in your list and be willing to break an element into smaller units if the facts call for it. Example number 5. False imprisonment. Rule. False imprisonment is confinement of a person within fixed boundaries set by another person who intended to restrain the movement of the person confined. False imprisonment is a common law cause of action and, as such, is a common law rule. False imprisonment is a tort cause of action. Other frequently used torts include negligence, medical malpractice, libel, wrongful adoption, strict liability in tort, and false light invasion of privacy. Each of these tort causes of action, like false imprisonment, has its own elements. A major non-tort cause of action is breach of contract. Elements of false imprisonment: 1. Confinement. 2. Of a person. 3. Within set boundaries. 4. By another person. 5. Who intended to restrain the movement of the person confined. If these elements apply, the consequence is that false imprisonment has been committed. Other rules will state other consequences, such as the payment of damages. Analyze this. Locate your state's simple assault statute and determine the elements using the methodology of element identification. Example number 6. Place of trial. Rule Statute 971.22. A party may move for a change of the place of trial on the ground that an impartial trial cannot be had in the county. The motion must be made at the time of arraignment. If Statute 971.22 applies, parties will know whether they can request a change in the place of the trial and when they must request the change. This is the consequence of the rule. Elements of Statute 971.22: 1. A party. 2. Move for a change of the place of trial. 3. On the ground that an impartial trial. 4. Cannot be had in the county. 5. The motion. 6. Must be made at the time of the arraignment. Here's another version. Elements of 971.22: 1. A party. 2. At the time of the arraignment. 3. Move for a change of the place of trial. 4. On the ground that an impartial trial cannot be had in the county. When you list elements, you are not casting them in stone. Variations are possible. As your analysis proceeds, you may consider a different listing of elements, so long as you are rigorously faithful to the language of the rule. You can shift the order of the language if this helps you organize your thoughts about the rule, so long as a shift does not change the meaning of any of the elements. Example number 7. Wrongful adoption. Rule: an action for wrongful adoption exists for failing to disclose to prospective adoptive parents known facts or conditions that would be relevant to the decision on whether to adopt. Elements of wrongful adoption: 1. Failing to disclose. 2. Known facts or conditions. 3. To prospective adoptive parents. 4. That would be relevant to the decision on whether to adopt. This is another common law rule on the tort cause of action for wrongful adoption. The consequence of the elements applying is that the tort or wrongful adoption has been committed. Note the word or in the second element when or means two or more alternatives that will satisfy a requirement. Place all of the alternatives within the same element. If, however, the rule contains language separated by and, additional requirements are usually indicated. Each additional requirement should be stated in its own element. The same is true if and or is implied rather than explicitly stated in the rule. Note also that the language in the listing of the four elements of wrongful adoption does not follow the same sequence as the language in the rule itself. The list places known facts or conditions immediately after disclose, so long as the meaning of the rule is not changed. It can be appropriate to alter the sequence of the language in the rule when this is helpful in understanding and analyzing the rule. Example number 8, expenses of litigation. Rule, statute number 5. While representing a client in connection with contemplated or pending litigation, a lawyer shall not advance or guarantee financial assistance to his client, except that a lawyer may advance or guarantee court costs, expenses of investigation, expenses of medical examination, and costs of obtaining and presenting evidence, provided the client remains ultimately liable for such expenses. Some rules, particularly statutes and regulations, can be difficult to break into elements when they contain lists, alternatives, exceptions, provisos, or conditions. Nevertheless, the same process is used. Take the time to dissect the rule into its component elements. Don't be reluctant to bring subject and verb closer together when the meaning is not changed. Elements of Statute 5. 1. A lawyer. 2. Representing a client in connection with contemplated litigation or in connection with pending litigation. 3. Shall not advance financial assistance to his client or guarantee financial assistance to his client, except that the following is proper. A. Lawyer advances or guarantees court costs provided the client remains ultimately liable for such expenses, or B. Lawyer advances or guarantees expenses of investigation provided the client remains ultimately liable for such expenses, or C. Lawyer advances or guarantees expenses of medical examination provided the client remains ultimately liable for such expenses, or D. Lawyer advances or guarantees costs of obtaining and presenting evidence provided the client remains ultimately liable for such expenses. Section 5 tells us what a lawyer shall not do. The consequence of the elements applying is that the attorney has violated Statute 5. Section 5 contains several alternatives. Note how they are clustered together with the element to which they relate. The same is true of the exception clauses in the rule. Don't be reluctant to repeat parts of the rule within the elements, particularly when the subject and object, or the subject and modifying clause, are far apart in long rules. Reread Statute 5 again slowly, and then note how the elements repeat clauses in this way. The most complicated element of Statute 5 is the third, 3. It contains lists, alternatives, and an exception. It contains lists, alternatives, an exception, and a proviso. But they all relate to the same point: the propriety of advancing, providing, or guaranteeing financial assistance to a client. None of the subdivisions of the third element should be stated as a separate element, because all the or options relate to the element of whether the items listed shall or shall not be advanced or guaranteed. 8-2b, Guidelines for Identifying Elements. A summary of the guidelines for identifying elements are as follows. Step 1. To begin your analysis, start by determining the elements of the problem or issue in the case. An element is a portion of a rule that is a precondition of the applicability of the entire rule. The skill of element identification requires you to make a list of these elements. Element identification is done in your head, on a scrap piece of paper, or making notes on your computer. It is not handed in to anyone. It is one of the preliminary tasks of legal analysis. There is often more than one way to list elements. Be prepared to try different combinations in the list. The facts will suggest to you how narrow your list of elements should be. See example number 4 on the two lists for Statute 109. Step 2. The starting point in your analysis is a rule, such as a statute or common law rule. Know the consequence of the rule if it applies. The consequence may or may not be stated within the rule. The consequence might be to allow something, to forbid something, to define something, etc. The elements of the rule will tell us when this consequence will be effective. In general, don't list the consequence as one of the elements. Step 3. Read the rule carefully. Make a list of all the essential parts of the rule. This list comprises the elements of the rule. Use the exact language of the rule in your list of elements. Don't paraphrase with synonyms or use your language. You can, however, make some adjustments in the order of the language, so long as you do not change the language or alter the meaning of the rule. One adjustment that may add clarity is to bring verbs and subjects closer together. See example number 7. Another is to repeat subjects, clauses, prepositions, or phrases that clearly go together. See example number 8. Step 4. Be cognizant of the language within the rule. Rules often contain and lists. If the items in the list are joined by and, treat each of the items as a separate element. The and will either be explicit or implied. And tells you what additional items are required. Additionally, rules often contain or lists. If the items in the list are joined by or, you are being told about alternatives. Keep all of the or alternatives within the same element. See examples number 7 and number 8. The or will either be explicit or implied. Rules often contain exception clauses. State them within the relevant element when they are related to the applicability of that element. See example number 8. Exception clauses do not contain new requirements. Rather, they tell us when a requirement does not apply. Step 5. Read for comprehension, as some rules are very long. A statute, for example, may contain dozens of sentences. The likelihood is that such statutes consist of more than one rule. Look for the possibility that each complete sentence in the statute is a separate rule or sub-rule with its own elements. The main takeaway from the guidelines for identifying the elements of a legal issue is take your time and read the rule carefully, in many cases slowly. Legal language is not always clear and can seem confusing when first reviewed. Do not rush the process. Give yourself time and patience to allow the information to resonate in your brain. It usually will take more than one reading to grasp the context of the legal information. The most important exercise is to follow the steps in the guidelines as you commence your analysis of the legal issues. 8-2C, Additional Benefits of Element Identification. Element identification has many uses in the law in addition to being an early step in legal analysis. Exhibit 8-2 outlines these other benefits. For example, knowing the elements of rules can help give direction to interviewing and investigation, which will be discussed in later chapters. When you interview and investigate, you are looking for relevant facts. How do you know which facts are relevant? One of the ways is to identify the elements of the potentially applicable rules that both sides will be arguing in the litigation. Facts are relevant if they help show that those elements apply or do not apply. As you can see from Exhibit 8-2, element identification will also help identify issues, draft complaints and answers, conduct depositions, organize memos, and charge the jury. And element identification is important for answering exam questions as well. Thus, element identification is one of the main building blocks in understanding a client's case. Think of it as the foundation of any case that is presented to you. Exhibit 8-2, Uses of Element Identification. Identifying issues. Once you identify the elements of a rule, the next step is to find the elements that are most likely to be in contention between the parties. These elements become the basis of issues, as we shall see in the next section. Drafting a complaint. A complaint is the plaintiff's first formal litigation document. It is the plaintiff's first pleading. The complaint states a cause of action against the defendant. When drafting a complaint, you often organize your factual allegations around the major elements of the cause of action. Drafting defenses. An answer is the first pleading of the defendant that responds to the plaintiff's cause of action. The answer will often assert defenses such as the statute of limitations. When drafting an answer to a complaint, you often state your defenses by alleging facts that support the elements of each defense. Organizing an interview of a client. One of the goals of interviewing a client is to obtain facts that are relevant to every element of the potential causes of action and defenses in the case. Element analysis, therefore, helps you organize the interview and give it direction. Organizing an investigation. One of the goals of investigation is to obtain facts relevant to every element of the potential causes of action and defenses in the case. Element analysis, therefore, helps you organize the investigation and give it direction. Conducting a deposition. A deposition is a method of discovery by which parties and their prospective witnesses are questioned by the opposing party outside the courtroom before trial. During a deposition, many of the attorney's questions are designed to identify facts that are relevant to the elements of the potential causes of action and defenses in the case. Element analysis, therefore, helps the attorney organize the deposition and give it direction. Organizing a memorandum of law. A memorandum of law is a written explanation of how one or more rules might apply to the facts of a client's case. The memorandum is organized by issues which are based on elements of rules that are in contention. Element analysis, therefore, helps identify what is covered and what will be emphasized in the memorandum of law. Organizing an examination answer. Some essay examinations in school are designed to find out if the student is able to identify and define the major elements of the rules that should be analyzed. Charging a jury. When judges instruct a jury, they will go over each of the elements of the causes of action and defenses in the case. They will tell the jury what standard to use, like, for example, beyond a reasonable doubt or preponderance of the evidence, to determine whether facts in support of those elements have been sufficiently proven during the trial. Element analysis, therefore, helps the judge organize the charge and give it direction. Eight 3 Legal analysis skills. Issue spotting and phrasing. Identifying elements, as we have seen, is the first step of legal analysis after you have found a rule and want to determine whether it applies to the facts of the client's case. We will turn now to the next skill, which is the identification of issues, issue spotting. This skill will also be dependent on a proper identification of elements. In the broadest sense, an issue is a question that needs to be answered or resolved, usually because of uncertainty or dispute. There are two main categories of issues: factual issues, also called issues of fact or fact questions; legal issues, also called issues of law or legal questions. A factual issue is raised when we want to know what happened. A legal issue is raised when we want to know what the law is, what the law means, or how the law applies to a specific fact. Examples of factual issues: was the employee denied a bonus in 2023? How long has Jones been receiving unemployment compensation? What did the parties intend when the buyer agreed in writing to pay the cost of the delivery? Who was present when the vote was taken by the board of directors? Is Anton Davis the biological father of Denise Odell's child? Examples of legal issues. Is a bonus includable in the taxable income of an employee? Is Jones eligible for unemployment compensation? Can oral statements be introduced to prove a party's intention when the parties have a written contract? Are the minutes of a meeting of the board of directors conclusive evidence of who was present at the meeting? Is Anton Davis obligated to take and pay for a DNA paternity test? In a jury trial, the jury answers factual issues in the verdict and the judge answers legal issues in the judgment. Conclusions on factual issues are called findings. Conclusions on factual issues are called findings. Conclusions on legal issues are called rulings and holdings. In a bench trial, there is no jury, so the judge resolves both factual and legal issues. Most of the issues we will be covering in this chapter will be legal issues. The legal issues presented in the above lists are in a shorthand or abbreviated format. We need to learn how to phrase legal issues in their comprehensive format. With this background, we turn to the interrelated skills of identifying legal issues, issue spotting, and phrasing them properly. You identify an issue when you identify the element in contention. Once you break a rule into its elements, you then determine which element or elements the parties will dispute. An element they will dispute is an element in contention. Such an element then becomes the basis of a legal issue. See Exhibit 8-3. If a rule has 5 elements and you anticipate disagreement over all of them, phrase 5 separate issues. If, however, only one of the 5 elements will probably be in contention, phrase only one issue. There is no need to waste time over elements that will not be the basis of disagreement. Exhibit 8-3, element in contention as the basis of an issue. Rule, elements of the rule, element in contention equals issue. An element is in contention when you can predict that the two sides in the controversy will probably not agree. 1. On the definition of the element. 2. On whether the facts fit within the element. Or 3. On both the definition and whether the facts fit within it. Definition of the element. Example: the plaintiff and defendant have different interpretations of the meaning of timely in Statute 55. Whether the facts fit within the element. Example: the parties agree on the meaning of timely, but disagree on whether the motion was timely filed when it was given to the clerk 2 hours after the deadline and the delay was caused by a snowstorm. Both the definition and whether the facts fit within it. Example: the parties disagree on the meaning of timely in Statute 55 and on whether the motion was timely filed when it was given to the clerk 2 hours after the deadline and the delay was caused by a snowstorm. Let's look again at the 8 examples we examined earlier. For each of the rules, you will find a set of facts. By examining these facts, you should be able to anticipate the dispute between the parties, which will lead you to the element in contention. 8-3A. Examples. Example number 1. Co-op. Facts. Bill and his neighbors have formed a downtown food co-op called Neighbors Together, through which members buy their food collectively from a wholesale company. All funds received by the co-op go for expenses and the purchase of more food to sell. There is no profit distributed to individual members. The city wants the co-op to obtain a commercial license. The co-op says the license law, Statute 10, does not apply to co-ops. Rule Statute 10. Any business operating within the city must obtain a commercial license. Elements of Statute 10. 1. Any business. 2. Operating within the city. The second element is not in contention. The facts say that the co-op is downtown, presumably within the city in question. There is no need, therefore, to base a legal issue on the second element. The element in contention is the first element. The co-op and the city will disagree on whether the co-op is a business within the meaning of Statute 10. Their contention over this element is its definition. There are 2 main ways to phrase issues, shorthand and comprehensive. Both consist of only one sentence. Do not phrase a legal issue in more than one sentence. Shorthand statement of an issue. During informal discussions in a law office, you will often find that attorneys and paralegals phrase legal issues in a broad, abbreviated fashion. Examples. Was Tom negligent? Does Statute 12 apply? Can we use the trespass definition? These are shorthand statements of issues because they state few or no facts and say little or nothing about the element in contention. Comprehensive statement of an issue. Although shorthand issue statements can be useful starting points for discussion, you need to be able to provide a more comprehensive statement of the issue. This is done by including in your issue a brief quote from the element in contention and several of the important facts that are relevant to that contention. In our co-op example, here are the shorthand and comprehensive statements of the issue. Issue, shorthand, 2 examples. Does Statute 10 apply? Is the co-op a business under Statute 10? Issue, comprehensive. Is a food co-op a business under Statute 10? Even though the co-op uses its proceeds for expenses and to buy additional food rather than as profits for individual members of the co-op. Note the following points about the comprehensive statement of the issue. The issue uses an even though clause. The use of the phrase even though, or when, or if is often an effective way to state facts that are relevant to the element in contention. The issue does not mention any proper names. The fact that the co-op is called Neighbors Together is not relevant to the element in contention. The issue would be the same if it had some other name. The issue would not be wrong if it included proper names. They are simply not needed. What is often important is the category in which major facts fit. Neighbors Together is a food co-op. The issue begins with the element in contention and concludes with the facts relevant to the contention. Facts are stated throughout the issue, but the facts most relevant to the contention are stated after, even though, when, or if. There are other acceptable ways to phrase legal issues for a comprehensive statement. They are: 1. a brief quote from the element of the rule in contention, and 2, several of the important facts that are relevant to that contention. The same legal issue can be phrased in different ways so long as these two essentials are always included. The examples that follow use language such as is, has, when, if, and whether to introduce and connect the two essential elements. Be prepared, however, to use other language when it better fits the flow of the issue you are stating. Furthermore, these ways to phrase an issue are not exhaustive. Other ways are possible, so long as the two critical components are present. There are a variety of ways to structure a legal issue. State the element in contention before the relevant facts. Is or has or does or similar verb. Include here a short quote from the element in contention, even though or when. Include here a brief statement of facts relevant to that contention. Example: is a food co-op a business under Statute 10, even though the co-op uses its proceeds for expenses and to buy additional food rather than as profit for individual members of the co-op? Has there been a forfeiture of a tax refund under Statute 612 when the taxpayer fails to allege misconduct by the investigating auditors? State the relevant facts before the element in contention, when or similar introductory word. Include here brief statement of facts relevant to the element in contention. Is or has. Include here a short quote from the element in contention. Example: when a food co-op uses its proceeds for expenses and to buy additional food rather than as profit for individual members, is the co-op a business under Statute 10? When the taxpayer fails to allege misconduct by the investigating auditors, has there been a forfeiture of a tax refund under Statute 612? Begin by stating the nature of the action. Start with the nature of the suit or action being brought, and then present the elements in contention before the relevant facts, or the relevant facts before the element in contention. Example: in an action to require a license, is a food co-op a business under Statute 10, even though the co-op uses its proceeds for expenses and to buy additional food rather than as profit for individual members? In an action for a refund, has there been a forfeiture of the refund under Statute 612 when the taxpayer fails to allege misconduct by the investigating auditors? Use a whether and or if, or a whether and or when sentence. Start with the word whether, and then present the element in contention before the relevant facts, or the relevant facts before the element in contention. A question mark is not needed at the end of such issue statements. The first example is in a whether and if format. It begins with the word whether, quoting from the element in contention, and then uses the word if, stating the facts relevant to that contention. The second example is in a whether and when format. It begins with the word whether, quoting from the element in contention, and then uses the word when, stating the facts relevant to that contention. Example: whether a food co-op is a business under Statute 10, if the co-op uses its proceeds for expenses and to buy additional food rather than as profit for individual members. Whether there has been a forfeiture of the refund under Statute 612, when the taxpayer fails to allege misconduct by the investigating auditors. Now let's consider example number 2 in understanding how to frame the issue. Example number 2, bike on road. Facts. Alex pedals their 10-speed bicycle on the sidewalk. They are charged with violating Statute 92B. Rule Statute 92B. The operator of any vehicle riding on a sidewalk shall be fined $100. Elements of Statute 92B. 1. Operator. 2. Any vehicle. 3. Riding. 4. On a sidewalk. The parties will agree that Alex rode their bicycle on a sidewalk and that Alex rode the bicycle. The first, third, and fourth elements, therefore, should not be made into legal issues. The only disagreement will be over the second element. Hence, it is the element in contention and the basis of the issue. Issue. Shorthand. 2 examples. Did Alex violate Statute 92A? Is a bike a vehicle under Statute 92A? Issue. Comprehensive. Is a 10-speed bicycle riding on the sidewalk a vehicle under Statute 92A when the bicycle runs on pedal power? Example number 3, pharmacy. Facts. Harry O'Brien, the pharmacist at the ABC drugstore, fills a prescription of Vicodin for Helen Jarvis. Helen pays by credit card. Helen is 15 years old. With the parents' permission, Helen is legally married in the state. Rule Statute 25-403. A pharmacist must not sell prescription drugs to a minor. Elements of Statute 25-403. 1. Pharmacist. 2. Sell 3 prescription drugs, 4 to a minor. The first 3 elements are not in contention. O'Brien is a pharmacist who sold a drug. We are told that the pharmacist filled a prescription for the drug. Therefore, it is a prescription drug. The element in contention will be the fourth. Issue. Shorthand. 2 examples. Was Statute 25-403 violated? Is a married 15-year-old person a minor under Statute 25-403? Issue. Comprehensive. Has a pharmacist sold a prescription drug to a minor under Statute 25-403 when the buyer is 15 years old and legally married? Note that the name of the specific drug, Vicodin, is not mentioned in the issue, nor is the fact that the payment was by credit card. These facts do not appear to be relevant to the main element in contention, whether the buyer was a minor. The issue would not be wrong if these facts were included in the issue, but they are not needed to understand the nature of the contention. For the same reason, the names of the people involved, Harry O'Brien and Helen Jarvis, are omitted. This particular legal issue is the same regardless of proper name or gender. Example 4. Additional punishment. Facts. On December 12, 2023, John Smith was arrested at 465 East 8th Street, South Boston at midnight. He was observed selling a substance to another adult, his brother Richard Smith. The substance was later determined to be heroin. When John Smith was arrested on East 8th Street immediately after the sale, Officer Frank Doyle searched him and found a loaded gun in his back pocket. Doyle was not aware of the presence of the gun until this search. At the trial, Smith was convicted of selling heroin. During sentencing, the prosecution asked for additional punishment under Statute 109 because Smith used a weapon in the commission of a drug crime. Rule Statute 109. A judge may impose additional punishment when a weapon is used by the accused in the commission of a drug offense. Elements of Statute 109. 1. Judge. 2. Weapon. 3. Is used. 4. In the commission of a drug offense. 5. By the accused. The first, second, fourth, and fifth elements won't be in connection. The first, second, fourth, and fifth elements won't be in contention. A loaded gun is a weapon. Selling heroin is a drug offense, which Smith is charged with committing, and John Smith is the accused. The parties are not going to disagree about these facts. There will be contention, however, over whether the weapon was used in the commission of a drug offense. Hence, an issue should be based on the third element because it is the element in contention. Issue shorthand, 2 examples. Was the gun used for purposes of Statute 109? Can additional punishment be added under Statute 109? Issue comprehensive, 2 examples. Is a gun used in the commission of a drug offense under Statute 109? When the gun is loaded and is in the back pocket of the accused at the time Smith is arrested for selling heroin, even though the gun played no active role in the drug offense. When an accused has a loaded gun in their back pocket at the time they are arrested for selling heroin, has the accused used the gun while committing a drug offense under Statute 109, even though the gun played no active role in the offense? Example number 5, false imprisonment. Facts. After George falls asleep in the room, Ted locks the door to the room, knowing that George would not be able to get out. The door is the only way in and out of the room. Before George wakes up, someone else unlocks the door so that when George wakes up and goes out, they never knew that the room had been unlocked. Rule: false imprisonment is confinement of a person within fixed boundaries set by another person who intended to restrain the movement of the person confined. Elements of false imprisonment: 1. Confinement. 2. Of a person. 3. Within set boundaries. 4. By another person. 5. Who intended to restrain the movement of the person confined. The second and fourth elements are not in contention because the parties will agree that George and Ted are persons. The parties will probably also agree that a room with only one way in and out constitutes set boundaries, so that the third element is not in contention. There is every indication that Ted intended to prevent George from getting out of the room when Ted locked it. Hence, the fifth element is unlikely to be in contention, but they probably will disagree with whether the first element applies. The disagreement will be over the definition of confinement, or its verb form confined. Ted will argue that you can't be confined by a locked door if you were never aware of the door being locked and never had difficulty getting out. The door was locked only while George was asleep. George will argue that awareness is irrelevant because the room was in fact locked while they were in it. Issue shorthand, 2 examples. Was George falsely imprisoned? Can you be confined if you don't know about it? Issue comprehensive. In an action for false imprisonment, has there been a confinement of a person when they are locked in a room while asleep, even though the door was no longer locked when they awoke and left? Example number 6. Place of trial. Facts. During a hearing on the arraignment of Helen Foley for possession of marijuana in Essex County, the prosecutor asks the judge to move the trial to Fairfax County, a neighboring county, because Helen is a reporter for an Essex County newspaper and has written stories attacking the prosecutor. The prosecutor alleges that these stories have negatively affected the potential pool of jurors for the trial of Foley. Foley objects to the prosecutor's motion. Rule Statute 971.22. A party may move for a change of the place of trial on the ground that an impartial trial cannot be had in the county. The motion must be made at the time of arraignment. Elements of Statute 971.22 will use the alternative listing of elements discussed earlier. 1. A party. 2. At the time of the arraignment. 3. Move for a change of the place of trial. 4. On the ground that an impartial trial cannot be had in the county. The first and second elements will not be in contention. The prosecutor is a party and is making the motion during the arraignment. The third elements will not be in contention because the prosecutor is making a motion for a change in the place of the trial. The element in contention is the fourth element. The parties will disagree over whether Foley's newspaper stories could affect the impartiality of the trial in Essex County. Issue shorthand, 2 examples. Do newspaper attacks on the prosecutor affect impartiality under Statute 971.22? Can the prosecutor get the trial moved under Statute 971.22? Issue comprehensive. When a newspaper reporter charged with a drug offense has written stories attacking the prosecutor, can the prosecutor obtain a change in the place of trial under Statute 971.22 on the ground that an impartial trial cannot be had in the county because of the stories? Example number 7. Wrongful adoption. Facts. Jim and Grace Thompson adopted a child Through the ABC adoption service, ABC told the Thompsons that the child had a heart condition, but it failed to tell them that the child had a baby sister who recently died of a heart attack. The agency knew about the death, but did not think it was relevant to the adoption by the Thompsons. The Thompsons sue ABC for wrongful adoption. Rule: an action for wrongful adoption exists for failing to disclose to prospective adoptive parents known facts or conditions that would be relevant to the decision on whether to adopt. Elements of wrongful adoption: 1. Failing to disclose 2. known facts or conditions 3. to prospective adoptive parents 4. that would be relevant to the decision on whether to adopt. Only the fourth element is in contention. ABC knew about the death of the sister but failed to disclose it to the prospective patients, the Thompsons. Only the fourth element is in contention. ABC knew about the death of the sister but failed to disclose it to the prospective parents, the Thompsons. The parties will disagree about whether this failure was relevant. Issue: shorthand. 2 examples. Was the failure to disclose the death relevant to the adoption? Was there a wrongful adoption? Issue: comprehensive. In an action for wrongful adoption of a child with a known heart condition, is the undisclosed recent death of a young sibling from a heart attack relevant to the decision to adopt the child? Example number 8. Expenses of litigation. Facts: T.K. Jacobs, Esquire, represents Bob Carey in his negligence action against another driver. T.K. wants to hire an expert witness for the case in order to secure some important evidence. The cost of the witness is $4,000. Bob does not have this amount. T.K. agrees to pay the fee of the expert. Bob agrees to let T.K. deduct this amount from an award of damages from the other driver in this case. Unfortunately, Bob loses the case and refuses to pay T.K. the $4,000. When attempts to collect the monies are made, Bob brings an ethics charge against T.K. before the State Bar Association for violating statute number 5. Rule: statute 5. While representing a client in connection with contemplated or pending litigation, a lawyer shall not advance or guarantee financial assistance to their client, except that a lawyer may advance or guarantee court costs, expenses of investigation, expenses of medical examination, and costs of obtaining and presenting evidence, provided the client remains ultimately liable for such expenses. Elements of statute number 5. 1. A lawyer. 2. Representing a client in connection with contemplated litigation or in connection with pending litigation. 3. Shall not advance financial assistance to his client or guarantee financial assistance to the client, except that the following is proper. A. Lawyer advances or guarantees court costs provided the client remains ultimately liable for such expenses, or B. Lawyer advances or guarantees expenses of investigation provided the client remains ultimately liable for such expenses, or C. Lawyer advances or guarantees expenses of medical examination provided the client remains ultimately liable for such expenses, or D. Lawyer advances or guarantees costs of obtaining and presenting evidence provided the client remains ultimately liable for such expenses. The first element is not in contention because TK is a lawyer. The second element is not in contention because what TK did, paying for the expert, was done in connection with pending litigation. The third element is in contention. TK advances costs of obtaining and presenting evidence, but Bob agrees to let TK deduct this amount from an award of damages from the other driver in the case. There are two issues in this case, a factual issue and a legal issue. Factual issue. First, there is a factual issue on the agreement between TK and Bob. What was their agreement on payments for the expenses of the expert? We are told that Bob agrees to let TK deduct this amount from an award of damages from the other driver. TK will argue that the agreement was not to forgive the debt if the case is lost. The agreement was to allow TK to deduct the $4,000 from the winnings, if any, and if the case was lost, Bob impliedly agreed to pay this amount. Bob, on the other hand, would agree that the agreement was that TK would pay for the witness, and absorb this cost if the case was lost. The dispute is factual. What did they intend? What did they agree to do when they discussed the witness fee? Factual issue. Did the parties agree that Bob would reimburse TK for the $4,000 witness fee, whether or not they won the case? Unlike the legal issues we have been discussing, the statement of factual issues is fairly straightforward. There is no need to make specific reference to the element in contention, although this element will be the focus of the factual dispute. Simply state the factual issue. Also, for factual issues, include the actual names of the parties, again, unlike legal issues. Legal issue. The legal issue in example 8 is based the third element, specifically on the definition of ultimately liable. Under the third element, the lawyer can advance litigation expenses if provided. The client is ultimately responsible for paying back the advance. If the factual question is resolved by concluding that Bob must pay the $4,000, whether or not the case is won, then there is no legal issue. If they must pay it back, regardless of the outcome of the case, then they are ultimately liable for it. The legal issue arises only if the factual issue is resolved by concluding that the attorney agreed to forget the $4,000 if Bob loses the case. Hence, the legal issue will be phrased on the assumption that this is what the attorney agreed to do. Issue shorthand. Has TK Jacobs violated Statute 5? Issue comprehensive. Does a lawyer violate Statute 5 when advancing the cost of an expert witness for a client who is ultimately liable to repay the lawyer only if the client wins the case? This relationship between factual issues and legal issues is common. Often a legal issue will arise only if a factual issue is resolved in a certain way. For a summary of the guidelines for identifying and phrasing legal issues, let's review the following. Note: these guidelines assume you have found a rule and want to identify and phrase the legal issue based on that rule. Identify the rule the parties will be disputing. Break the rule into its elements and identify the element that will be in contention. The contention will be over the definition of the element, whether the facts fit within the element, or both the definition and whether the facts fit within the element. The contention will be over the definition of the element, whether the facts fit within the element, or both the definition and whether the facts fit within the element. Identify the specific language in the element in contention that is at the center of the dispute. Give a comprehensive statement of the issue. The two critical components of a comprehensive statement of an issue are a brief quote from the element in contention and several of the important facts that are relevant to that contention. Put quotation marks around the specific language of the element in contention. Phrase the issue in one sentence. Do not include complete citations to the rule in the issue, but include the section number. If a statute or regulation or the name of the cause of action, like for example negligence, include several facts that are most relevant to the dispute over the specific language in the element in contention. In a legal issue, do not include the specific names of any of the parties or major participants. Instead, think of relevant categories into which they fit, like for example spouse, seller, business, and child. A category is relevant if it is related to the element in contention. There is no minimum or maximum length for legal issues. A comprehensive statement of an issue should be long enough to comply with the above guidelines, but not be so long that it is unreadable or in violation of grammar. Review the previous discussion on variations for the structure of the issue. You have more flexibility is phrasing factual issues. You have more flexibility is phrasing factual issues. State the essence of the dispute. Include the actual names of the parties or major participants in the dispute. Lawhorn v. Allen, 519 F. 3D 1272 11th Circuit 2008 is a case where an attorney either did not read or misread a rule that had a significant effect on a murder case. The case presented literally a life or death issue, and whether the attorney's decision to forego a closing argument at a sentence hearing was proper under Alabama law. As it turned out, the attorney's legal analysis was faulty. Order of the Court, a case study. Lawhorn v. Allen, United States Court of Appeals for the 11th Circuit, 519 F3D 1272, 11th Circuit, 2008. In Lawhorn v. Allen, we are faced with several legal issues in a habeas corpus matter. However, we will limit our review to the claims of ineffective assistance of counsel of the defendant, James Lawhorn's defense counsel. Here, Lawhorn was arrested for murder of William Berry, to which he ultimately confessed. One of the crucial issues that remained in his case was the sentence, the death penalty or life without parole. Lawhorn was represented by an attorney, Hank Fannin, who waived closing arguments at his sentencing hearing. Apparently, his attorney misread an Alabama statute that stated if the defendant does not make a closing argument, then the state is foreclosed from making a closing argument. This reading of the statute was made in error. One of the issues that the appeals court reviewed was whether defense counsel's decision not to present closing argument in a capital murder case was considered ineffective assistance of counsel. The 11th Circuit found that Fannin's representation was deficient because he had an erroneous belief that if he did not present a closing at sentencing, the prosecution would be precluded from making further arguments in rebuttal. Fannin stated that he presented a case to the lower court which supposedly confirmed his position, which the record showed he did not. The court stated that Fannin's position was prejudicial to his client in that he never presented an argument, humanizing his client and asking for mercy from the jury, who was going to pronounce sentence on Lawhorn. The court applied the landmark U.S. Supreme Court case of Strickland v. Washington, 466 U.S. 688, 1984, which sets forth the test for ineffective assistance of counsel. It states that an attorney's performance is deficient, ineffective, so that the deficient performance prejudiced the defense, because the errors were so serious as to deprive the defendant of a fair trial, a trial whose result is reliable. The court went on to quote Strickland further in stating that it is the burden of the petitioner to prove ineffective assistance, with the exception if the circumstances of defense counsel's effective assistance are so likely to prejudice the accused that the cost of litigating their effect is unjustified. Such circumstances exist in a case where the accused is denied counsel at a critical stage of this trial, or where counsel entirely fails to subject the prosecution's case to meaningful adversarial testing. ID at 1293-2994. A closing argument is a critical state of a trial. ID. Here, the court looked to the fact that only did Fannin misread the law, a rule, and a case, but failed to perform any analysis or legal research that would have revealed that waiving closing argument in this type of capital murder case was prejudicial to his client. The court noted the importance of closing arguments, especially in a capital murder setting, when a defense attorney can remind a fact finder jury of circumstances that could lessen the impact of the crime by humanizing the defendant and detailing family history, life experiences, and other salient facts in an attempt to save the defendant from a sentence of death. But Fannin's decision to not present a closing argument eliminated that opportunity for Lawhorn. Thus, the court found that Fannin was ineffective and ordered a new sentencing hearing. Discussion questions. Review Lawhorn v. Allen. Outline the facts of the underlying case and the procedural history of the case. What other issues were before the federal appeals court? What case did the defense attorney rely upon that was misplaced? What actions did the court focus on that led them to their result? Was the result fair? Explain your response. 8-4 Legal Analysis Skills Definitions. Next, we turn to the definition skill. Important language in the element in contention must be defined. This is so even if the parties are likely to agree over the definition but disagree over whether the facts fit within the definition. Where do you obtain the definitions? You use a two-step approach. First, you try to define the terms on your own based on everyday language, the context of the rule, and common sense. Then you check the validity of your definitions by doing legal research of primary authority to find out. If a court opinion provides a definition, if a statute of the legislature provides a definition, if an administrative regulation or administrative decision provides a definition. In addition, if the rule is a statute, check the legislative history of the statute for clues to meaning and definition. And finally, find out if discussions of the rule in respected secondary authority, such as a law review, article, or legal treatise, provide clues to meaning and definition. As we will see in Chapter 9, courts are not obligated to agree with secondary authority, but a court may find the discussion persuasive. See the section on persuasive authority in Chapter 9. In Chapter 9, we will study legal research techniques of finding cases, statutes, regulations, decisions, legislative history, and secondary authority. In this chapter, we will use the first step of identifying definitions, coming up with definitions on your own based on the meaning of everyday language, the context of the language in the rule, common sense, and your best guess of the definition each side to the dispute is likely to propose. In many cases, terms that need a definition can be defined broadly or narrowly. Decide which party would favor the broad definition and provide it. Decide which party would favor the narrow definition and provide it. Let's look again at the examples we have been following. Example number 1, co-op. Facts. Bill and his neighbors have formed a downtown food co-op, neighbors together, through which members buy their food collectively from a wholesale company. All funds received by the co-op go for expenses and the purchase of more food to sell. There is no profit distributed to individual members. The city wants the co-op to obtain a commercial license. The co-op says the license law, Statute 10, does not apply to co-ops. Rule Statute 10. Any business operating within the city must obtain a commercial license. Issue. Is food a co-op a business under Statute 10, even though the co-op uses its proceeds for expenses and to buy additional food rather than as profits for individual members of the co-op? Bill and the co-op would argue for a narrow definition of business to avoid being classified as one. The city, on the other hand, would seek a broader definition that would encompass the co-op. Narrow definition. A business is a venture in which a person or persons invest funds or other resources in order to earn a profit that can be distributed and used by the individual investors. Broad definition. A business is a venture in which a person or persons invest funds or other resources with the objective of earning a return that is greater than its investment. To help support its definition, each party will do legal research to try to find primary and secondary authority on the meaning of the rule and of the element in contention. While doing the research, the parties may find support for other definitions. Example 2, bike on road. Facts. Alex pedals their 10-speed bicycle on the sidewalk. They are charged with violating Statute 92B. Rule Statute 92B. The operator of any vehicle riding on a sidewalk shall be fined $100. Issue. Is a 10-speed bicycle riding on the sidewalk a vehicle under Statute 92B when the bicycle runs on pedal power? Alex would argue for a narrow definition of vehicle to avoid being classified as one. The police, on the other hand, would seek a broader definition that would encompass the bicycle. Narrow definition. Vehicle means any motorized method of transportation. Broad definition. Vehicle means any method of transportation. To help support its definition, each party will do legal research to try to find primary and secondary authority on the meaning of the rule and of the element in contention. While doing the research, the parties may find support for other definitions. Example number 3. Facts. Harry O'Brien, the pharmacist at the ABC drugstore, fills a prescription of Vicodin for Helen Jarvis. Helen pays by credit card. Helen is 15 years old. With the parents' permission, Helen is legally married in the state. Rule.
Statute 25-403, a pharmacist must not sell prescription drugs to a minor. Issue: has a pharmacist sold a prescription drug to a minor under Statute 25-403 when the buyer is 15 years old and legally married? Harry O'Brien would argue for a narrow definition of minor so that Helen would not be classified as one. The state, on the other hand, would seek a broader definition that would include Helen. Narrow definition: a minor is any person under the age of 18 unless that person has obtained legal independence, emancipation, such as by being legally married. Broad definition: a minor is any person under the age of 18. To help support its definition, each party will do legal research to try to find primary and secondary authority on the meaning of the rule and of the element in contention. While doing the research, the parties may find support for other definitions. Example number 4, additional punishment. Facts: on December 12, 2023, John Smith was arrested at 465 East 8th Street, South Boston at midnight. He was observed selling a substance to another adult, his brother, Richard Smith. The substance was later determined to be heroin. When John Smith was arrested on East 8th Street immediately after the sale, Officer Frank Doyle searched him and found a loaded gun in his back pocket. Doyle was not aware of the presence of the gun until this search. At the trial, Smith was convicted of selling heroin. During sentencing, the prosecution asked for additional punishment under Statute 109 because Smith used a weapon in the commission of a drug crime. Rule Statute 109, a judge may impose additional punishment when a weapon is used by the accused in the commission of a drug offense. Issue: is a drug used in the commission of a drug offense under Statute 109 when the gun is loaded and is in the back pocket of the accused at the time they are arrested for selling heroin, even though the gun played no active role in the drug offense? John Smith would argue for a narrow definition of used to demonstrate that there was no use. The prosecution, on the other hand, would seek a broader definition that would include the gun in Smith's pocket. Narrow definition: used means actively employing or activating a weapon for the purpose of committing the drug offense for which a person is arrested. Broad definition: used means having a weapon in one's possession and readily available as needed while a person is committing a drug crime. To help support its definition, each party will do legal research to try to find primary and secondary authority on the meaning of the rule and of the element in contention. While doing the research, the parties may find support for other definitions. Example number 5, false imprisonment. Facts: after George falls asleep in a room, Ted locks the door to the room, knowing that George would not be able to get out. The door is the only way in and out of the room. Before George wakes up, someone else unlocks the door so that when George wakes up and goes out, they never knew that the room had been locked. Rule: false imprisonment is confinement of a person within fixed boundaries set by another person who intended to restrain the movement of the person confined. Issue: in an action for false imprisonment, has there been a confinement of a person if they are locked in a room while asleep, even though the door was no longer locked when they awoke and left? Ted would argue for a narrow definition of confinement to avoid being charged with false imprisonment. George, on the other hand, would seek a broader definition that would include what Ted did. Narrow definition: confinement is the complete restraint of a person's freedom of movement within fixed boundaries while the person is aware of the restraint. Broad definition: confinement is the complete restraint of a person's freedom of movement within fixed boundaries. To help support its definition, each party will do legal research to try to find primary and secondary authority on the meaning of the rule and of the element in contention. While doing the research, the parties may find support for other definitions. Example number 6, place of trial. Facts: during a hearing on the arraignment of Helen Foley for possession of marijuana in Essex County, the prosecutor asks the judge to move the trial to Fairfax County, a neighboring county, because Helen is a reporter for an Essex County newspaper and has written stories attacking the prosecutor. The prosecutor alleges that these stories have negatively affected the potential pool for jurors for the trial of Foley. Foley objects to the prosecutor's motion. Rule Statute 971.22, a party may move for a change of the place of trial on the ground that an impartial trial cannot be had in the county. The motion must be made at the time of arraignment. Issue: when a newspaper reporter charged with a drug offense has written stories attacking the prosecutor, can the prosecutor obtain a change in the place of of the trial under Statute 971.22 on the ground that an impartial trial cannot be had in the county because of the stories. Fully would agree for a narrow definition of impartial trial in order to increase the likelihood that the judge will deny the motion to move the trial. The prosecutor will argue for a broad definition in order to increase the likelihood the motion will be granted. Narrow definition. Impartial trial means the absence of outside influences that are highly likely to impact the fairness of the trial. Broad definition. Impartial trial means the absence of outside influences that could in any way impact the fairness of the trial. To help support its definition, each party will do legal research to try to find primary and secondary authority on the meaning of the rule and of the element in contention. While doing the research, the parties may find support for other definitions. Example number 7, wrongful adoption. Facts. Jim and Grace Thompson adopted a child through the ABC Adoption Service. ABC told the Thompsons that the child had a heart condition, but it failed to tell them that the child had a baby sister who recently died of a heart attack. The agency knew about the death, but did not think it was relevant to the adoption by the Thompsons. The Thompsons sue ABC for wrongful adoption. Rule. An action for wrongful adoption exists for failing to disclose the prospective adoptive parents' known facts or conditions that would be relevant to the decision on whether to adopt. Issue. In an action for wrongful adoption of a child with a known heart condition, is the undisclosed recent death of a young sibling from a heart attack relevant to the decision to adopt the child? ABC will argue for a narrow definition in order to increase the likelihood that the failure to disclose will not be found relevant. The Thompsons will argue for a broad definition of relevant in order to increase the likelihood that the failure to disclose was relevant. Narrow definition. Relevant means whatever a reasonable prospective adoptive parent would consider critical information about the child. Broad definition. Relevant means whatever the prospective adoptive parents would consider important information about the child. To help support its definition, each party will do legal research to try to find primary and secondary authority on the meaning of the rule and of the element in contention. While doing the research, the parties may find support for other definitions. Example 8, expenses of litigation. Facts. T.K. Jacobs, Esquire, represents Bob Carey in a negligence action against another driver. T.K. wants to hire an expert witness for the driver in order to secure some important evidence. The cost of the witness is $4,000. Bob does not have this amount. TK agrees to pay the fee of the expert. Bob agrees to let TK deduct this amount from an award of damages from the other driver in the case. Unfortunately, Bob loses the case and refuses to pay TK the $4,000. When TK tries to collect it from Bob, they bring an ethics charge against them before the State Bar Association for violating Statute 5. Rule. Statute 5. While representing a client in connection with contemplated or pending litigation, a lawyer shall not advance or guarantee financial assistance to their client, except that a lawyer may advance or guarantee court costs, expenses of investigation, expenses of medical examination, and costs of obtaining and presenting evidence, provided the client remains ultimately liable for such expenses. Issue. Does a lawyer violate Statute 5 when they advance the cost of an expert witness for a client who is ultimately liable, to repay the lawyer only if the client wins the case? T.K. Jacobs is being charged with a violation of Statute 5. They can escape sanctions by showing that the agreement with the client required repayment of the witness fee, regardless of who wins the case. Hence, T.K. would like a broad definition of ultimately liable, whereas Bob Carey, hoping to avoid the payment, would argue for a narrow definition. Narrow definition. Ultimately liable means responsible for payment if the client wins damages from which payment can be made. Broad definition. Ultimately liable. It means responsible for payment regardless of who wins the case. To help support its definition, each party will do legal research to try to find primary and secondary authority on the meaning of the rule and of the element in contention. While doing the research, the parties may find support for other definitions. Online exercises. Locate a copy of your state's Open Records Act, similar to the Freedom of Information Act. What is included in the definition of the document? What are the exceptions? Can 911 calls be requested under the state's Open Records Act or its equivalent? Analyze this. Based on the definition of a document in your state's Open Records Act or equivalent, frame the issue based upon a request by a news outlet for the 911 recording of a witness to a murder case. Prepare the issue from the state's perspective as not wanting to release the 911 recording, or if your state has a statute addressing 911 calls, draft the issue according to the statute. For a summary review of the guidelines on definitions and legal analysis, the following provides assistance. Identify the language in the rule that needs a definition. It will be language in the element in contention. The language will be in dispute because the parties disagree over the definition of the language, disagree over whether the facts fit within the definition, or disagree over both the definition and whether the facts fit within it. Attempt to define the language on your own based on the meaning of everyday language, the context of the language in the rule, common sense, and your best guess of the definition each side to the dispute is likely to propose. Ask yourself whether the language can be defined broadly and narrowly, and if so, which side would argue for the broad definition and which side would argue for the narrow definition. Put yourself in the shoes of each person in the controversy and try to identify what definitions of the language each would propose. Do legal research on the language. Find out if the language has been defined by a court opinion. If the language is in a statute, find out if there is a definition statute that is part of the same cluster of statutes. If the language is in a statute, check to see if the legislative history of the statute will help you define the language. Find out of any administrative regulations and administrative decisions have interpreted the language. Find out if the secondary authority, like for example a law review article or legal treatise, has interpreted the language. We will cover these and other legal research topics in Chapter 9. If the language has been defined by a controlling opinion, statute, or other primary authority, the definition is binding regardless of the definitions you came up with on your own. Don't be surprised, however, to discover that some language, particularly in statutes, has never been defined by court opinions, statutes, or other primary authority. Return to our facts. At the beginning of the chapter, it seems as though the client has to determine what the Clean Air Act requires when a refinery is restarting operations and not building new construction. Part of your analysis should be to review the definition section within the Clean Air Act to determine what is required under the statutory language, if anything, by the client. Thus, based on our facts, after framing the issue, you should locate a copy of the definition section of the Act and start identifying the elements of the applicable definition and its requirements. You have now started the beginning phases of legal analysis, which is framing the issue and locating the applicable statutory law. Remember, this is only the beginning of the process. In later chapters, we will build on our legal analysis by performing legal research and crafting our final document, usually a legal memorandum that will test your writing, researching, and analytical skills. 8-5 Legal Analysis Skills, Factor Analysis. Thus far, we have concentrated on the analysis of elements and rules. Elements are preconditions to the applicability of the entire rule. If one element does not apply, the entire rule does not apply. We now turn to a closely related but different kind of analysis, factor analysis. A factor is one of the circumstances or considerations that will be weighed in making a decision. Of which neither is conclusive. A factor is one of the circumstances or considerations that will be weighed in making a decision, of which neither is conclusive. Elements and factors are closely related. Many of the important decisions we make in everyday life involve the equivalent of elements and factors, like for example buying a home, accepting a job offer, and picking someone to marry. When people look for a house, they consider space, neighborhood, area, schools, affordability, etc. If an item is essential, it is an element. Suppose, for example, that you will not buy a house with less than 3 bedrooms. This is a precondition to the entire purchase. In the same manner as any single element of a rule is a precondition to the applicability of the entire rule. A house hunter may also want a large yard and a bus line within walking distance. But if these are not preconditions, they are simply factors to be considered, neither of which is dispositive or essential. If the bus line is a factor, the house hunter may decide to buy a particular house even though the bus line is not within walking distance. Why? Because this negative fact was examined in the light of everything else about the house. Like, for example, the price was fair, the house had a very large yard, it was the right color, it needed few repairs. And on balance, the decision was to make the purchase. The bus line problem did not outweigh all of the other factors. In a similar fashion, factors often play an important role in legal analysis. For example, Statute 20. In a hearing to determine whether the penalty for non-payment of a tax can be waived, the agency shall consider the amount of the non-payment, the timing of the failure to pay, and the extent to which the non-payment occurred intentionally or accidentally. Elements of Statute 20. 1. In a hearing. 2. To determine whether the penalty for non-payment of tax can be waived. 3. The agency 4 shall consider A. The amount of the non-payment, and B. The timing of the failure to pay, and C. The extent to which the non-payment occurred intentionally or accidentally. The word "and" in factor analysis means that every factor must be considered. Note that "and" is expressly mentioned once in Statute 20 and implied twice in the list of factors. The word "waived" is not defined in Statute 20. Instead of a definition, we are given a list of 3 items that will be considered by the agency in deciding whether to grant a waiver. 1. The amount of the non-payment. 2. The timing of the failure to pay. And 3. The extent to which the non-payment occurred intentionally or accidentally. Nothing in this list is dispositive. Each item on the list is a factor that must be weighed to determine whether a penalty will be waived. These factors are a requirement of the 4th element of Statute 20. Once you find factors in a rule, you simply examine the factors one at a time by connecting the facts that you have or that you must investigate to each factor. Further investigation is often called for because of the large number of facts that are usually needed to assess each of the factors mentioned in a rule. One of the benefits of this kind of analysis is that it will help the office identify these investigation needs. There are no magic words that will always signal the need for a factor analysis. You must examine the rule carefully to determine whether you are being told that several items mentioned in the rule must be weighed in order to decide whether the rule applies. The rule may or may not use the word factor in the list. Other words that might indicate factors are consideration, consider circumstances, assess, and evaluate. The test is whether it is clear from the rule that everything on the list must be weighed or considered. Factor analysis requires a balancing act to determine whether an element applies. Each factor is to be considered and balanced against the other factors. Now is a good opportunity to review our facts from the beginning of the chapter and determine what our issues may be based on. Now is a good opportunity to review our facts from the beginning of the chapter and determine what our issues may be based on the limited facts that we have so far. We know that our client, the refinery, needs to understand whether a permit is required for starting up the refinery. The issue may be framed as follows. Under the Clean Air Act, is the refinery required to procure a new permit even though it is only restarting operations? Since we do not know many specifics, we craft a general issue as a starting point until we learn more facts to narrow our issue. We also seem to have another issue percolating in that the EPA appears to have changed its position on requiring a permit after the refinery began the process of restarting its operations. Here we do not know many facts, and thus the issue will be very general to start. Can the EPA change its position on whether a permit is needed to restart operations of a refinery? Some of the issues that you should be thinking about is how can the EPA change its position after the refinery already began the process of restart and had invested tens of millions of dollars based on previous representations? Is it fair to the refinery to be required to procure a permit after the process of restart had begun? Think about the other issues that may apply. You now are engaging in the process of legal analysis. Technology updates. Legal chatbots. Technology changes so quickly that it is often difficult to keep up with it, especially in today's world. One of those additions to the world of legal technology are legal chatbots. There are messaging apps that you can download to a smartphone that can answer legal questions as though you are talking to a human. In fact, the question is being posed to a computer program. Legal chatbots are not designed, at least not yet, to provide reliable responses to complex legal issues. But the technology has advanced sufficiently to allow quick answers to basic legal issues, such as asking what the applicable rules are for seeking a divorce from a spouse in a community property state, or what are the relevant laws for adoption in your state. Tools like Facebook Messenger use the chatbot technology to respond to basic legal questions. For those that do not have access to lawyers, legal chatbots may fill in a gap, thus bridging the often discussed access to justice gap. However, the knowledge base of chatbots is only as good as the information inputted into their systems. They rely on pre-programmed information, and if a question goes beyond what they are programmed to do, inaccurate or incorrect information is relayed. The person using the legal chatbot will more likely have no idea that the information is incorrect and rely on the responses to that person's detriment. The key that individuals should know about chatbots is their limitations, and they are not a replacement for the analysis and thought processes that attorneys utilize when dissecting a legal problem. So far, legal chatbots cannot perform that type of in-depth thinking, but this technology is developing at a rapid pace. What any legal profession should be mindful of is their existence and use, as well as the drawbacks of the information that they may provide. It may be a buyer beware scenario, which suggests that you should know where information is originating, and in many cases, good old-fashioned legal work will still be the standard of the day. 8-6 Memorandum of Law. We turn now one of the written products of the skills we have been discussing. The word memo, has several meanings. It can refer to a short note, a written record of transaction, or a memorandum of law. A memorandum of law is a written explanation of how one or more rules might apply to the facts of a client's case. There are two main audiences for a memorandum of law. Internal audience. If the memo is written solely for individuals in the office where the writer of the memo works, the memo is called Office Memorandum of Law, Inter-Office Memorandum of Law, or simply Office Memo. Such memos must be honest about the strengths and weaknesses of the client's case. An internal memorandum is objective in that it points out the weaknesses as well as the strengths. Such honesty will help the attorney devise an appropriate strategy for the client. External audience. An external memo is addressed to someone outside the office, such as opposing counsel, a judge, or an agency hearing officer. Most memoranda for an external audience are advocacy documents that stress the strengths and downplay the weaknesses of the client's case. Here are some of the major categories of external memos. Points and authorities. Memorandum, trial memorandum, or hearing memorandum. These are examples of memos submitted to a judge or agency hearing officer. Memorandum in support of a motion. If the memo is offered to support a request or a motion, like for example, for a waiver of filing fees, the name of the memorandum will include its purpose, like for example, memorandum in support of a motion for a waiver of filing fees. Most of the discussion that follows is on the internal memorandum of law. One of the guidelines that can be helpful in organizing a memorandum is IRAC, or its modified version IFRAC, or FIRAC. 8-6A IRAC. When your supervisors were in law school, many of their first-year law professors probably taught them IRAC. IRAC is an acronym that stands for four components of legal analysis. Issue I, Rule R, application of the rule to the facts A, also called analysis or discussion, conclusion C. An acronym is simply a memory aid formed by the initial letters and words you want to remember. IRAC provides a structure for legal analysis and can be helpful when you are ready to organize your memo. Let's take a closer look at the IRAC and its variation, IFRAC. 8-6B IRAC. State the issue. I. The issue is based on the element in contention. State the rule R you are trying to apply to the facts. The rule, of course, will include the element in contention. Apply the rule to the facts. A. More specifically, apply the definition of the language of the element that is in contention. Show how both sides would argue their positions. State the conclusion. C. Which side do you think has the better argument on whether the rule applies to the facts? Note that IRAC does not have a separate step for stating the facts, which are critically important in legal analysis. IRAC usually certainly includes the facts in their legal analysis, usually after stating the issues, but they don't make it part of their acronym. We however, will place the facts F into the acronym so that it becomes IFRAC. Issue I, Facts F, Rule R. Application of the rule to the facts A, also called analysis or discussion, conclusion C. 8-6C, IFRAC or FIRAC. IFRAC is a modification of the IRAC acronym by adding facts F. IFRAC. State the issue I. The issue is based on the element in contention. State the facts F that have raised the issue. State the rule R you are trying to apply to the facts. The rule, of course, will include the element in contention. Apply the rule to the facts A. More specifically, apply the definition of the language of the element that is in contention. Show how both sides would argue their positions. State the conclusion C. Which side do you think has the better argument on whether the rule applies to the facts? Again, IFRAC is not different from IRAC. Both discuss facts. The difference is that the IFRAC acronym is explicit on including facts. See Exhibit 8-4. Exhibit 8-4. Basic structure of legal analysis, issue, facts, rule, application, and conclusion, IFRAC. Issue plus facts plus rule plus application equals conclusion. In your academic and paralegal career, you may find that others want you to use a different structure for your written legal analysis. Don't let this concern you. Adapt to what your teachers and supervisors want. Rest assured, however, that the core components, the building blocks of the analysis will always be the same, whether the guideline is IRAC, IFRAC, or some other approach. Learn the basics of IFRAC here, but be flexible and be prepared for variety in how different people write out the basics in documents such as the Memorandum of Law. Online exercise. Identify two other acronyms used in place of IRAC or IFRAC. What do those acronyms stand for? 8-6D. Sections of a memo. A memorandum of law can have the following sections: heading, introduction, issue and summary conclusions, facts, rules, application, also called analysis or discussion, conclusions, recommendations if needed, appendix if needed. As we examine these sections, you will note that after the preliminary sections, heading and introduction, the memo proceeds by following the IFRAC sequence. In the examples, we will be using the skills discussed earlier, breaking rules into elements, identifying and phrasing issues based on the element in contention, defining important language in the element, and applying those definitions to the facts. Heading. In the heading section of the memo, you include basic information about you and the nature of the memo. See the examples in Exhibits 8-6 and 8-7. Title. A center title at the top of the page stating the kind of document it is, Office Memorandum of Law. 2. The name of the person to whom the memo is addressed, usually your supervisor, with their title, from your name with title, the author of the memo, date, the date of the memo was completed and submitted, case, the name of the case, client's name and opponent, if any, office file number, the internal numbering and or lettering system used by the office to identify files of its clients, kind of case, the general area of law covered in the memo, docket number. The docket number is the number assigned to the case by the court clerk if the suit has already been filed in court. RE. The notion RE means regarding, concerning, or in the matter of. The notion is followed by a very brief summary of the subject matter of the memo, often in the form of a shorthand statement of the issue. Oftentimes, some of the information in the heading is combined, for example, in the regarding clause, or as some refer to it as the re clause. Much of the information will be combined so that the heading is as follows. Office Memorandum of Law, March 1st, 2024. To Nicole Morgan Sylvester, Esquire, Senior Partner. From Julio D. Ramos, Paralegal. RE, Alliance Projects vs. Charities Incorporated, case number 2023 CV 2894. Office file number Civil 2023 456 NMS. Whether Alliance Projects is liable for debts under the purchase and sale of Charities Incorporated. Quick tip: to add a level of confidentiality and protection, add in over the heading the words attorney-client work product privilege. This will indicate unequivocally that the information contained in the memorandum is only intended for internal use only by those involved in the case. Introduction. In the introduction section of the memo, you write a short roadmap paragraph and state any limitations that have been imposed on your assignment. A roadmap paragraph is an overview or thesis paragraph that tells the reader what issues will be covered and briefly states the conclusions that will be reached. Examples. Introduction. This memorandum examines the question of whether Statute 34-304G of the Civil Code allows substituted service after making only one attempt to serve the defendant at his last known address. Although there are no cases analyzing this new statute, the best reasoning is that it does not allow such service. Introduction. This memorandum examines the question of whether cyanide sulfate falls within the category of prohibited substances under Statute 154(1)(c) of the Environmental Code. It does. Note that the introduction contains a more elaborate presentation of what was briefly summarized in the heading under kind of case and RE. Often your supervisor will place restrictions or limitations on what the memo should or should not cover. If so, they should be added to the introduction paragraph. Examples. You have asked me not to examine the issue of damages. You have asked me to spend no more than 4 hours on the assignment. You have asked me not to use fee-based online research services at this time. If you have any difficulty writing the statement of the assignment, consult with your supervisor immediately. The time to clarify what you are to do and what you are not to do is before you spend extensive time researching, analyzing, and writing. The value of clearly articulating the boundary lines of the memo cannot be overemphasized. Finally, include in the introduction any assumptions that you have been asked to make. Examples. You have asked me to assume that only New York law applies, or you have asked me to discuss New York law only. You have asked me to discuss the constitutionality of the client's statement to the police on the assumption that the state will be able to convince a trial judge that the statement was not privileged. Issues and summary conclusions. In the issues and summary conclusions section of the memo, you lay out all of the issues and conclusions. As we have seen, the two critical components of a legal issue are 1. A brief quote from the element of the rule in contention, and 2. Several of the important facts relevant to that contention. After you have stated the issues, tell the reader what your answers are in the form of summary conclusions. Later in the memo, you will elaborate on the conclusions as needed. Here you provide short answers to the issues raised. Example of issues and summary conclusions. Issues. 1. Under the statute of frauds, does a purchase option constitute an agreement that can be performed within a year if the option cannot be exercised before the completion of construction, which is expected to take 18 months? 2. Does the substantial impairment exception of Statute 745 of the Corporations Code apply to filing requirements imposed by the government even though the date of incorporation has passed? Summary conclusions. 1. Yes, the year requirement of the statute of frauds can encompass estimated times. 2. No, the statute 745 exception is activated only when the interference results from conduct of the shareholders. Additionally, these sanctions may be styled issues and answers to the issues. Either presentation is acceptable. It simply depends on the preference of the attorney with whom you are preparing the memo. Also, some attorneys prefer an issue be styled beginning with the word whether and not in a question format. Framed with the word whether, our example above would be 1. Whether under the statute of frauds, a purchase option constitutes an agreement that can be performed within a year if the option cannot be exercised before the completion of construction, which is expected to take 18 months. Quick tip: whether is a statement, not a question. Whether it is a statement, not a question. Whether is a statement, not a question. If framing the issue beginning with the word whether, do not end that statement with a question mark. Facts. In the Facts F section of the memo, you take great pains to ensure that the statement of facts is concise, accurate, and well organized. The facts should be stated in the memo even if you and your supervisor are familiar with the facts. Later, there may be other readers of the memo who are not as familiar with them. The statement of facts should include the following: all legally relevant facts. A fact is legally relevant if it will help prove or disprove one of the elements of a cause of action or a defense. Unknown facts. Include facts that are unknown as of the date of the memo if they would be relevant to the dispute. Example: we do not know if the substance seized by the police is a drug because the lab report has not yet been completed. Favorable and unfavorable facts. The reader of an office memo needs an accurate picture of what happened in order to formulate an effective strategy on behalf of the client. This requires an honest and complete presentation of every relevant fact, regardless of which side it favors. Example: the client insists that he paid for the service with cash. Thus far, however, we have not been able to locate a receipt or other indication that the payment was made. Procedural facts. If the client's case is already in litigation, include a summary of what has happened in court to date. The procedural facts. Example: on March 26, 2023, we filed an action for medical malpractice against Sutter Hospital on behalf of Johnson and are now waiting for service of its answer. Then proceed to the non-procedural facts of the dispute. Do not state legal conclusions in the statement of facts, and do not be argumentative. State the facts as objectively as you can. If the statement of facts is fairly long, you might begin with a 1 or 2 sentence summary of the facts. For example, facts: during 12 years of employment at Sinclair Chemicals Incorporated, Mary Kiley was subjected to numerous instances of sexual harassment when she began work there in 2010. She then provided a chronological statement of the detailed facts. Occasional variations from strict chronological order can be justified as long as they do not interfere with the flow of the story. Sometimes it is useful to divide complicated facts into broad categories or topics. Suppose, for example, your office represents 3 companies suing the same distributor for breach of contract. One way to present the facts would be to begin with the facts that pertain to all three. These facts would be stated chronologically. Then you would list each company individually and provide separate statements of facts, again in chronological order, that pertain to each company. An alternative to a chronological statement of facts is a statement that is organized around specific topics or subject matters. For example, there may be separate subheadings for background facts, employment, termination, damages, and etc. All of the facts related to these topics could be clustered under them. Exhibit 8-5 presents a synopsis of what to include when preparing your fact statement. Exhibit 8-5, summary of facts to include in fact statements in memorandum. Facts to include in statement of facts in memorandum. All legally relevant facts, unknown facts, favorable and unfavorable facts, procedural facts. Rules. In the Rule R section of the memo, you list the pertinent parts. In the Rule R section of the memo, you list the pertinent parts of each rule that will be discussed. The rule will be the basis of a legal issue. If a rule is long, part of the rule can be given in the body of the memo, and the full rule can be given in the appendix at the end of the memo. As indicated earlier, the most frequent rules involved in legal disputes are statutes, administrative regulations, common law rules, and constitutional provisions. Each rule can be the basis of a separate issue. Alternatively, an issue might consist of more than one rule, such as whether an administrative regulation violates a statute or whether a statute violates the Constitution. For each rule, give its complete citation. If the rule is a common law rule, the citation will be to the court opinion that applies the rule. Application, also called analysis or discussion. In the Application A section of the memo, you apply the rules to the facts in order to try to answer the legal issue. As indicated, the section more than likely will be called analysis or discussion. Assume that the rule being applied is a statute. Here is a summary of the steps that would be taken. Break the statute into elements. List each element separately. Briefly tell the reader which elements will be in contention and why. In effect, you are telling them why you have phrased the issues the way you did earlier in the memo. Go through each element you have identified one at a time, spending most of your time on the elements that are most in contention. For the elements not in contention, simply tell the reader why you think there will not be any dispute about them. For example, you anticipate that both sides will probably agree that the facts clearly support the applicability or non-applicability of the element. For the elements in contention, state the definition each side is likely to ask a court to adopt. Discuss court options, if any, that have interpreted the statute. Discuss administrative regulations and administrative decisions, if any, that have interpreted the statute. Discuss the legislative history of the statute, if any. Discuss scholarly interpretation of the statute, if any, and legal periodicals, legal treatises, and other secondary authority. Give opposing viewpoints for the elements in contention. Try to anticipate how the other side will interpret these elements. For example, what counter-analysis will the other side probably make through court opinions or legislative history? Counter-arguments are particularly important. Too often, a memo fails to provide them. Avoid presenting only one side in the memo, usually the side you think should win or the side your law office represents. For every sentence you write that contains any analysis or conclusion, use the stop technique. Stop after you write a sentence containing any analysis or conclusion. Think carefully about whether the other side would agree with the position you have just taken in that sentence. If you conclude, once you stop yourself, that the other side would not agree with what you have written, a counter-analysis to your position will be needed somewhere in the memo. The counter-analysis does not have to occur immediately after the sentence you wrote. You may decide to present counter-analysis in a separate paragraph or in a separate section of the memo. Stop is simply a technique to remind you that your analysis will not be complete until you have covered every position the other side will probably raise. Conclusions. In the Conclusion C section of the memo, you give your educated opinion as to which side has the better arguments based on the research and analysis performed. Do not share any new arguments in the conclusion. Simply state your perspective on the strengths and weaknesses of the arguments of both sides, which is based on the legal research performed for the assignment. Recommendations if needed. Include recommendations if you believe are appropriate in view of the analysis and conclusion you have provided. For example, further facts should be investigated, specify which ones. Further research should be undertaken, identify each issue in need of further research. A letter should be written to the government agency involved in the dispute, summarizing or submit a draft of the proposed letter. The case should be settled or litigated. Summarize why you think so, etc. If you have already stated your recommendations in the analysis section, of the memo, there may be no need for a separate recommendations section. Appendix if needed. At the end of the memo, include special items, if any, that you referred to in the memo, such as the full text of statutes or other rules, cases, photographs, and statistical tables. 8-6E Sample Memos. Exhibits 8-6 and 8-7 contain two examples of office memoranda. Both memos apply statutes. Later in the chapter, in Exhibit 8-14, you will find an example of a memo that applies a court opinion. Exhibit 8-6, Example 1, Memorandum of Law using IFRAC as a guide. Office Memorandum of Law, February 14, 2024. To Paula Adams, Esquire Senior Partner, from George Vance, Paralegal, RE, whether additional punishment can be added under Section Statute 109. Our case, State v. John Smith, criminal drug offense, office file number 24-391, docket number E-39571-24. Introduction. You have asked me to examine whether our client, John Smith, can receive additional punishment under Statute 109 of the Criminal Code because he had a weapon when he was arrested for drug possession. A strong argument can be made that he cannot. 2. Issue and summary conclusion. Issue is a gun used in the commission of a drug offense under Statute 109 when the gun is loaded and is in the back pocket of the accused at the time he is arrested for selling heroin, even though the gun played no active role in the drug offense. Summary conclusion. No additional punishment requires. Summary conclusion. No. Additional punishment requires more than mere possession of the weapon. 3. Facts. On December 12, 2023, John Smith was arrested at 465 East 8th Street, North Boston at midnight. He was observed selling a substance to another adult, his brother Richard Smith. The substance was later determined to be heroin when John Smith was arrested immediately after the sale. Officer Frank Doyle searched and found a gun in his back pocket. Doyle was not aware of the presence of the gun until this search. At the trial, Smith was convicted of selling heroin. During sentencing, the prosecution asked for additional punishment under Statute 109 because Smith used a weapon in the commission of a drug crime. Smith objected on the ground that he did not use the weapon within the meaning of Statute 109 because the gun had nothing to do with the heroin. rule, the governing rule in this case is Statute 109 of the Criminal Code, which provides as follows. Statute 109. A judge may impose additional punishment when a weapon is used by the accused in the commission of a drug offense. 12. State Criminal Code, Statute 109, 2012. Analysis. There are 5 elements of Statute 109. 1. Judge. 2. Weapon. 3. Is used. 4. In the commission of a drug offense. 5. By the accused. If these 5 elements apply, a judge can impose additional punishment on the defendant under Statute 109. There will not be any dispute between the parties on the first, second, fourth, and fifth elements. Both John Smith and the prosecutor will agree that the request is being made to a judge, that the gun is a weapon, and that it was found on the accused, Smith, who has committed a drug offense. The dispute will be over the third element, whether Smith used this weapon in the commission of a crime. The parties will disagree over the definition of used. Section 109 was enacted by the legislature last year. No state court has yet ruled on the definition of used in the statute. The prosecution will argue that used means having a weapon in one's possession and readily available as needed while engaged in a drug crime. Under this definition, Smith used the gun. A person with a gun in his pocket possesses the gun. The gun was loaded. Furthermore, Smith was in possession of the gun while Smith was selling heroin. Hence, he used the weapon in the commission of a crime. Smith, on the other hand, will argue that the prosecution's definition is too broad. When the legislature passed Statute 109, it intended the word used to mean actively employing or activating a weapon for the purpose of committing the drug offense. The legislature could have used the word possessed if it merely wanted the weapon to be present during the commission of a drug offense. Instead, however, the legislature wrote the word used, which has more active meaning than possessed. Smith can argue that he did nothing more than possess the weapon. Furthermore, it was concealed. He was not going to use it on his own brother. When Smith sold heroin to his brother, he never took out his gun. There is no evidence that his brother knew he was armed. John Smith never actively employed the gun by brandishing it, displaying it, striking anyone with it, or threatening to fire it. Hence, he never used the gun. Merely possessing it is not enough under Statute 109. If the weapon played no role in the commission of the drug offense, the legislature did not intend defendants to suffer additional punishment. Because Statute 109 is a very recent statute, there are no court cases interpreting it. Conclusion. Smith has the stronger argument. The word used requires actively beyond concealed, passive possession. Recommendation. The legislative history of Statute 109 should be checked to see if it sheds any light on what the legislature meant by used in the statute. Exhibit 8-7. Example number 2. Memorandum of Law using IFRAC as a guide. Office Memorandum of Law, March 23, 2024. To Daniel Farrell, Esquire, Senior Associate, from Paula Vargas, Paralegal, R.E., whether Donaldson has violated Statute 17 of the State Civil Code, alleged misuse of government property. Our case, Department of Sanitation v. Donaldson, office file number 24-114. Docket number, none at this time, no action has been filed. Introduction. You have asked me to do a preliminary analysis of 23 State Civil Code Statute 17 to assess whether our client, Jim Davidson, has violated this statute. The argument is strong that he did not. No research has been undertaken thus far, but I will indicate where such research should be pursued. 2. Issue a summary conclusion. Issue. When a government employee is asked to rent a car for his agency but makes personal use of the car before he signs the lease, has this employee violated Statute 17, which prohibits the use of property leased to the government for non-official purposes? Summary conclusion. No. Until the lease is signed, Statute 17 does not prohibit personal use. Facts. Jim Donaldson is a government employee who works for the State Department of Sanitation. On February 12, 2024, he is asked by his supervisor, Frederick Jackson, to rent a car for the agency for a 2-year period. At the ABC Car Rental Company, Donaldson is shown several cars available for rent. He asks the manager if he could test drive one of the cars before making a decision. The manager agrees. Donaldson then drives the car to his home in the area, picks up a TV, and takes it to his sister's home. When he returns, he tells the manager that he wants to rent the car for his agency. He signs the lease and takes the car to the agency. The supervisor, however, finds out about the trip that Donaldson made to his sister with the TV. He is charged with violating Statute 17. Because Donaldson is a new employee at the agency, he is fearful that he might lose his job. Rule. Section Statute 17 provides as follows. Statute 17, use of government property. An employee of any state agency shall not directly or indirectly use government property of any kind, including property leased to the government, for other than officially approved activities. 23 State Civil Code 8 and N Statute 17. Analysis. To establish a violation of Statute 17, the following elements must be proven. 1. An employee of any state agency. 2. A directly uses government property of any kind, including property leased to the government. Or B. Indirectly uses government property of any kind, including property leased to the government. 3. For other than officially approved activities. The main dispute in this case will be the second element. 1. Employee of a state agency. Donaldson works for the State Department of Sanitation, which is clearly a state agency under the statute. 2. Use of property leased to the government. The central issue is whether Donaldson used property leased to the government. There should be no dispute that when Donaldson drove the car to his sister's, he directly used property. He did not indirectly use property, such as by causing someone else to drive the car. The question is whether the car was property leased to the government within the meaning of Statute 17. Donaldson's best argument is a strong one. When he made the trip to his sister, he had not yet signed the lease. He can argue that leased means contractually committed to rent. The general definition of lease is as follows: a contract by which the rightful possessor of personal property conveys the right to use that property in exchange for consideration. Black's Law Dictionary 970 11th ed 2019. I have not yet checked whether courts in our state have adopted language similar to Black's Law Dictionary. Under this definition, the car did not become property leased to the government until after he returned from his sister's house. No costs were incurred by the government because of the test drive. Rental payments would not begin until the car was rented through the signing of the lease contract. The supervisor, on the other hand, will argue for a broader definition of leased, that it means the process of obtaining a contractual commitment to rent, including integral steps leading to that commitment. Under this definition, the car was leased to Donaldson when he made the unauthorized trip. The test drive was arguably an integral step in making the decision to sign a long-term leasing contract. The supervisor will stress that the goal or purpose of the legislature in enacting Statute 17 should be kept in mind when trying to determine the meaning of any language of Statute 17. The legislature was trying to avoid the misuse of government resources, including the good name of the government. Public employees should not take advantage of their position for private gain. To do so would be a violation of the public trust. Yet, this is what Donaldson did. While on the government payroll, he obtained access to a car and used it for a private trip. Common sense would lead to the conclusion that leasing in Statute 17 is not limited to the formal signing of a leasing contract. Anything that is an integral part of this process of signing that contract should be included. The legislature wanted to prevent the misuse of government resources in all necessary aspects of the leasing property. It is not clear from the facts whether the manager of the ABC rental company knew that Donaldson was considering the rental on behalf of a government agency when he received permission to take the test drive. The likelihood is that he did not know it, although this should be checked. If the manager did know, then Donaldson probably used the fact that he was a government employee to obtain the permission. He held himself out as a reliable individual because of the nature of his employment. This reinforces the misuse argument under the broader definition of leased that the supervisor will present. I have not yet checked whether there are any court opinions or agency regulations interpreting Statute 17 on this point, nor have I researched the legislative history of the statute. All this should be done soon. 3. Officially approved activities. Nothing in the facts indicates that Donaldson's supervisor gave him any authorization to make the TV trip. Even if the supervisor had authorized the trip, it would probably not be officially approved since the trip was not for official, i.e. public business. Conclusion. Donaldson has the stronger argument based on the language of the statute. The property simply was not leased at the time he made the TV trip. I must admit, however, that the agency has some good points in its favor. Unlike Donaldson's technical argument, the agency's position is grounded in common sense. Yet, on balance, Donaldson's argument should prevail. Recommendations. Some further investigation is needed. We should find out whether the ABC rental company manager knew that Donaldson was a government employee at the time he asked for the test drive. In addition, legal research should be taken to find out if any court opinions and agency regulations exist on the statute. I cited the definition of lease from Black's Law Dictionary, but I have not yet done any legal research to determine if the legislature intended the same meaning when it passed Statute 17. The legislative history of the statute should be checked. Finally, I recommend that we send a letter to Donaldson's supervisor, Frederick Jackson, explaining our position. I have attached a draft of such a letter for your signature in the event you deem this action appropriate. There is one matter that I have not addressed in this memo. Donaldson is concerned that he might lose his job over this incident. Assuming for the moment that he did violate Statute 17, it is not at all clear that the termination would be an appropriate sanction. The statute is silent on this point. Let me know if you want me to research this issue. Note that the memos in Exhibits 8-6 and 8-7 build on the skills we have been covering in this chapter. The rule is broken into its elements. The element in contention is identified and an issue is based on this element. A definition of the element is stated. Competing definitions are discussed. The structure of the memo follows IFRAC. The memo in Exhibit 8-6 is based on one of the examples we discussed earlier. Example number 4. The memo in Exhibit 8-6 includes the draft of a letter. Exhibit 8-8 that the letter of the memo recommends sending. Exhibit 8-8 draft a proposed letter for the Donaldson case. Farrell, Grote, and Schweitzer, attorneys at law, 724 Central Plaza Place, West Union, Ohio, 45693, 513-363-7519. Daniel Farrell, Esquire, Angela Grote, Clara Schweitzer, Esquire, March 25, 2024. Frederick Jackson, Field Supervisor, Department of Sanitation, 3416 34th Street, Northwest, West Union, Ohio, 45693. R.E. James Donaldson, our file 24-114. Dear Miss Jackson, our firm represents Mr. James Donaldson. As you know, a question has arisen concerning Mr. Donaldson's use of a car prior to his renting it for your agency on February 12, 2024. Our understanding is that he was asked to go to the ABC car rental company in order to rent a car that was needed by your agency, and that he did so satisfactorily. Your agency became responsible for the car at the moment Mr. Donaldson signed the lease for the car rental on behalf of the agency. What happened prior to the time the lease was signed is not relevant to statute. 17. This statute is quite explicit. It forbids non-official use of property leased to the government. Such use did not occur in this case. No one has questioned Mr. Donaldson's performance of his duty once he leased the car. If additional clarification is needed, we would be available to discuss this matter with you. Sincerely, Daniel Farrell, Esquire. Online exercise. Research the plural of the word memorandum. What are the different options for the plural spelling? (8-7). Introduction to court opinions.
An opinion is a court's written explanation of how it applied the law to the facts to resolve a legal dispute. An opinion is also called case, court opinion, judicial opinion, and decision. The word case has several definitions. In addition to meaning court opinion, a word also means a pending matter on a court calendar and a client matter handled by a law office. In this chapter, the words case and opinion will be used interchangeably to mean court opinion. Decisions of administrative agencies are also called opinions, although they are more commonly referred to as administrative decisions. Case analysis is opinion analysis. Case analysis is opinion analysis, the study and application of court opinions. In law school, students spend a great deal of time learning to be attorneys by doing case analysis. This approach to studying law is called the case method or the case book method. The opinions that they study are in thick textbooks, often over 1,000 pages long, called case books. Our goal here is to examine two major case analysis skills. 1. Reading cases, called briefing, and 2. Applying cases, sometimes called analogizing. Before we start learning the skill of briefing, we need to cover the meaning of the word brief and examine commonly found features of opinions printed in volumes called reporters. (8-7A). The meanings of brief. When someone uses the word brief, they can be referring to three different documents: case brief, trial brief, or appellate brief. Case brief. A brief consists of the 10 parts of a court opinion: citation, parties, objectives of the parties, theories of the litigation, history of the litigation, facts, issues, holdings, reasoning, and disposition. To brief an opinion is to identify these 10 parts. When you do so, you are briefing the opinion. A brief, sometimes called a case brief, is your own summary of the opinion for later use. You cannot apply an opinion, the main reason for reading opinions, unless you know how to brief it. Trial brief. A trial brief has two main meanings. First, it is an attorney's written presentation to a trial court of the legal issue and positions of their client, also called trial memorandum. Second, the phrase can mean attorneys' personal notes on how they will conduct a particular trial, also called trial manual or trial book. The notes, often placed in a trial notebook, will be on the opening statement, witnesses, exhibits, direct and cross-examination, closing argument, and etc. These notes are private. They are not submitted to the court or to opponents. Appellate brief. An appellate brief is a document that a party files with an appellate court and serves on an opponent, in which the party presents arguments on why the appellate court should affirm, approve, reverse, vacate, cancel, or otherwise modify what a lower court has done. A main focus of the appellate brief is on the claimed errors made below by a lower court. Here our concern is the first meaning of the word brief, the 10 parts of a court opinion. It should be pointed out that paralegals do not spend a lot of time on the job briefing opinions. Yet, learning this skill has important benefits. Briefing is an excellent way to increase your understanding of legal analysis as used by judges and attorneys. It will also provide a greater appreciation of how appellate courts and trial courts interrelate within a court system. 8-7b. Detailed examination of an opinion. All court opinions resolve a legal dispute by applying one or more rules to facts presented by parties in the dispute. The rules that the court applies can be a statute, administrative regulation, common law rule, constitutional provision, and etc. See the definitions of primary authorities in Chapter 7. As mentioned earlier, a common law rule is a rule created by the courts in the absence of controlling statutory law or other higher law. In an opinion, the court resolves the legal dispute by answering the legal issues involved in the dispute. This answer is called a holding. Each holding in an opinion becomes a new rule. Consequently, the opinion can be a precedent for future court opinions. We will now examine an opinion as it might appear in a library volume called a reporter, or through online sources such as Westlaw and Lexis. See Exhibit 8-9. When we say that a case is reported, we simply mean that it is in writing and usually printed in a reporter. The opinion is People v. Bruni, referred to in the discussion as the Bruni case or opinion, or simply as Bruni. Names of cases appear in italics. The publisher of this reporter is Thomson Reuters, though many of its publications are still known by the name West, which was the name of the company before it was acquired by Thomson Reuters. The publisher might also be listed as Thomson West. Most researchers prefer to call them West Publications, which we will do here. The circled numbers in the following paragraphs correspond to the circled numbers in the Bruni opinion in Exhibit 8-9. When the word Bruni is in italics, the reference is to the opinion. When Bruni is not in italics, the reference is to the party in the opinion. Ronald James Bruni. In the decision, the words opinion and case are used interchangeably to mean court opinion. 1. The California Reporter abbreviated CAL, California RPTR reporter, is an unofficial reporter of state opinions in California. The 100 indicates the volume number of the reporter. An unofficial reporter is a collection of cases printed by a private or commercial printer, publisher, here West without specific authorization from the government. If the opinion had such authorization, it would be an official reporter. 2. The Bruni opinion begins on page 600. The official citation, shortened to cite, is given at the top of the first column above the word people. The citation that includes both reporters containing this opinion is People vs. Bruni, 25 CAL APP 3D 196 100 CAL RPTR 600-1972. When more than one citation is available, each cite is a parallel cite. Citations are highly technical. Note the use of italics, abbreviations, punctuation, and spacing in this cite. We will have more to discuss about citation formatting in Chapter 9. An official cite is a reference to the opinion printed in its official reporter. An unofficial cite is a reference to the same opinion printed in an unofficial reporter. The official cite is always listed before the unofficial cite. The Bruni opinion does not have a public domain citation, a citation format that we will examine in Chapter 9. If public domain citation was used, every paragraph in the opinion would be separately and consecutively numbered. 1, 2, 3, and etc. There are 10 paragraphs in Bruni, so therefore the last paragraph would begin with 10. As we will see in Chapter 9, public domain citation allows you to quote from opinions that are published online where page numbers are not used. 3. When the people or the state brings an action, as here, it is often a criminal law opinion. People vs. Bruni is a criminal law opinion written by an appellate court. Trial court decisions are appealed to the appeal court. The appellant, also called the petitioner, is the party bringing the appeal because of disagreement with a decision from a lower tribunal. The state of California brought the case as the plaintiff, called the prosecutor in criminal cases, in the lower court, Superior Court, County of San Mateo, and is now the appellant in the higher court, Court of Appeal, 1st District, Division 1. 4. Ronald James Bruni was the defendant in the lower court because he was being sued or, in this criminal case, charged with a crime. The appeal is taken against him by the people appellant because the people believe that the lower court was in error when it ruled in favor of Bruni. The party against whom a case is brought on appeal is called the appellee, also called the respondent. 5. CR 10096 refers to the docket number of the case. CR stands for criminal. A docket number is a consecutive number assigned to a case by the court and used on all documents filed with the court during the litigation of that case. Think of the docket number as the administrative number assigned to a case. That number distinguishes the case from all other cases. Oftentimes, docket numbers provide important information. It normally tells you the year the case was filed, the type of case, criminal or civil, and often the division where the case was filed or assigned judge. For example, if the docket number is 2023 CR 267 Lewis, the docket number here tells us that the case was filed in 2023. It is a criminal case, as CR normally stands for criminal. The number stands for the 276 cases filed and assigned to Judge Lewis. Note that the docket number was not used in the citation of the case presented earlier. Docket numbers are not used in citations unless the opinion has not been reported. 6. Make careful note of the name of the court writing the opinion as soon as possible. You must learn the levels of state courts in your state. See Chapter 7. In many states, there are 3 levels of courts: trial level, intermediate, appellate level, and court of final resort level. Opinions in such states are appealed from the trial court to the intermediate appellate level, and then to the court of final resort. The court of final resort in most judicial systems is the Supreme Court. If a state has only 2 levels of courts, opinions are appealed from the trial court to the court of final resort. Here, we know from the title of the court that wrote People v. Bruni, Court of Appeal, that it is an appellate court. It is not the Supreme Court because in California, the highest court is the California Supreme Court. In California, the Court of Appeal is an intermediate appellate court. The level of the court is significant because of legal authority. If the court is the court of final resort, the Supreme Court of the state, then the opinion would govern and be followed and must be followed in similar future cases throughout the state. It is binding in future cases everywhere in the state. An intermediate appellate court opinion, however, would govern and must be followed in the similar future cases only in the geographic area over which that appellate court has jurisdiction. It is not binding in future cases throughout the state. When you see that the opinion was written by a trial or intermediate appellate court, you are immediately put on notice that you must check to determine whether the opinion was appealed subsequent to the date of the case. 2 of the main systems for checking the subsequent history of an opinion are Shepard's citations and Key Cite. As we will see in Chapter 9, these systems are called citators. 7. When an opinion is cited, only the year here, 1972, is used, not in the month or day, April 27th, if the opinion has not yet been reported. Then the month, day, and year are used, along with the docket number. Sometimes the text of the reported opinion will also give you other dates, like for example the date when a request for a rehearing was denied. The year of the decision is still the critical one for citation purposes. Here you are provided with a summary syllabus of what the opinion says. The summary provides the procedural background of the case, a few of the major facts, and what the court held. The last item refers to the holdings of the opinion. The publisher of these reporters, West, separates the syllabus into 2 parts. Background, consisting mostly of the procedural steps leading up to the present opinion, and holding, summarizing the holdings of the opinion. For most courts, the syllabus is written by an editor and not by the court itself. It is normally not considered part of the official opinion. 9. Here continues the unofficial summary, providing the reader with what procedurally must happen as a result of the April 27th opinion. 10. These are the editor's headnotes, which are short paragraph summaries of portions of the opinion, generally points of law within the case. Like the syllabus, headnotes are printed before the opinion begins. Each headnote covers a single point of law in the opinion. The beginnings of the 2 headnotes in Bruni are as follows. 1. Searches and seizures, 3.83. 2. Searches and seizures, 3.84. Note the sequence of the 4 parts: a number, a general topic, a key icon, and another number. Let's examine each part. The first number. Number 1 corresponds to bracketed number 1 in the opinion. Number 2 corresponds to bracketed number 2 in the opinion. See 10A for these bracketed numbers. When the editors first read the opinion, they decide how many points of law are covered in the opinion. Each of these points of law is summarized in a headnote, all of which are then given consecutive numbers, here 1 and 2. These numbers correspond with the bracketed numbers 1 and 2 in the opinion itself. If, for example, you wanted to read the portion of the opinion that was summarized in the second headnote of the opinion, you would go to the text of the opinion that begins with the bracketed 2. A general topic. Next comes a general topic. Here, searches and seizures. West has over 400 of these general topics, such as divorce, fraud, searches and seizures, and taxation. Remember that West is the name of the current publisher, Thomson Reuters. The key icon. The key icon tells you that you are using West's system of organizing topics found in court opinions. Another number. Following each key icon, there is another number here, 3.83 and 3.84. This number refers to a subtopic of the general topic. There are hundreds of subtopics of searches and seizures. A general topic and the subtopic number that follows it are called a key number. A key number, therefore, is a numbered subtopic of a general topic. Key numbers are used by West to organize millions of cases by subject matter. Headnotes are found in 3 places: at the beginning of opinions, in the digest volume of West, and on West Law. Digests are volumes containing headnotes clustered together by topic so that researchers can find similar cases. Although Westlaw may have different versions, such as Westlaw Next or Westlaw Precision, it is a fee-based system of computer-assisted legal research owned by Thomson Reuters. We will examine digests and Westlaw in Chapter 9. Caution is needed in reading the syllabus and headnotes of opinions. They are written by editors, not by the court, and therefore should never be quoted. They are merely preliminary guides to what is in an opinion. To understand the opinion, you must carefully study the language of the opinion itself through the process called briefing. Do not follow the example of what is pejoratively called a headnote lawyer, someone who overly relies on the summaries of an opinion found in its headnotes without taking the time to brief it in its entirety. Quick tip. Sometimes the headnote may contain a misstatement or inaccuracy. That is why you should never rely on the headnote in your legal analysis. Read the case section that the headnote cites, the original text. That is the law cited by the court in the court's own language. 11. Here are the attorneys who represented the appellant and appellee on appeal. Note that the Attorney General's office represented the people. The Attorney General or the District Attorney's office represents the state in criminal cases. For recent opinions, many of these offices have websites that can be useful if you want more information about them. 12. The opinion begins with the name of the judge who wrote the majority opinion, Judge Smith. In this spot, you will sometimes find the words per curiam opinion, or memorandum opinion. A per curiam opinion is a court opinion that does not mention the individual judge who wrote the opinion. The opinion is issued by the whole court. It is often a short opinion because it covers relatively straightforward issues. There are exceptions to this. For example, the famous case of Bush v. Gore, 531 U.S. 98, 2000, which led to the election of President George W. Bush, was a per curiam opinion. The name of the justice who wrote the Bush opinion was not given, but the issue resolved in the opinion could not be called simple. Memorandum opinions, like per curiam opinions, do not name the judge who wrote the opinion. A memorandum opinion will briefly state the conclusion, holding of the opinion, or disposition of the case, with few or no supporting reasons. Such opinions are issued when the point of law involved is well known or established. 13. When briefing an opinion, make note of the history of the litigation to date. The lower court rendered a judgment dismissing the information, similar to an indictment, against Bruni after certain evidence was suppressed and declared inadmissible. This is the prior proceeding. The people have now appealed the judgment. This appeal is the present proceeding. If the words information and suppression are new to you, look them up in a legal dictionary. Do this for every new word. In this book, also check the definitions of such words in the glossary. 14. It is critical to state the facts of the opinion accurately. Here the facts are straightforward. A search warrant that said daytime service was served at 9:30 p.m. and evidence was taken pursuant to this search warrant. Defendant objected to the admission of this evidence at trial. In most opinions, the facts are not this simple. The facts are usually given at the beginning of the opinion. In some opinions, however, the facts are scattered throughout the opinion. If you confront the latter situation, you must carefully read the entire opinion to piece the facts together. Ultimately, your goal is to identify the key facts of the opinion. A key fact is a fact that was very important or essential to a decision, here to the result or holding of the court. 15. The next step in reading an opinion is to state the legal issue or issues that the court was deciding. The issue in Bruni is as follows. When evidence is seized pursuant to a search warrant served at 9:30 p.m., can the evidence be suppressed under Statute 1529, which requires daytime service? See the discussion of phrasing issues earlier in the chapter in Exhibit 8-5. The issue should include a brief quote from the element of the rule in contention, the word daytime in Statute 1529, and several important facts relevant to that contention. The warrant was served at 9:30 p.m. 16. The court refers to other statutes to support the conclusion it will reach. Note the interrelationship of the statutory sections. One statute is interpreted by interpreting other statutes. Section 4 of the Penal Code, PENCODE, says that the sections of the Penal Code are to be interpreted, construed, according to the meaning and significance of their terms, according to the fair import of their terms, in order to carry out effect their purpose, objects, and to promote justice. Section 1859 of the Code of Civil Procedure, Code CIV, PROC, says that when a general and a particular section are inconsistent, the latter is preferred, paramount. The interrelationship of the statutes in this opinion is as follows. Section 1529 of the Penal Code still says daytime. Section 7 of the Penal Code defines daytime as sunrise to sunset. Section 1533 of the Penal Code, as amended, says between 7 a.m. and 10 p.m. Section 4 of the Penal Code and Statute 1859 of the Code of Civil Procedure provide principles for interpreting statutes that are inconsistent. 17. In the same manner, a court will refer to other opinions to support its ruling. In this way, the court argues that the other opinions are precedents for the issues before the court. The court in People v. Bruni is saying that the case of Department of Motor Vehicles of California v. Indus ACC COM and the case of Tidwell v. Superior Court are precedents for its own ruling. 15, 16, 18. The reasoning of the court is its explanation for resolving the issue the way it did. The reasoning tells us why the court reached the particular holding for that issue. The court's reasoning in Bruni is that if there is a general statute, such as Statute 1529, and a specific statute, such as Statute 1533, that are inconsistent, the specific is paramount and is preferred when this preference would render the statutes reasonable, fair, and harmonious. Hence, the legislature probably intended but forgot to amend the more general statute, Statute 1529, when it amended the more specific statute, Statute 1533. 18a. Note the use of the single quote mark, double quote mark, and single and double quote marks together. The double quotation marks are around the main quote. There is a quote within the main quote. The quote within the quote is indicated by single quote marks. Ellipses, dots, tell the reader that the court left out some language that was within the original quoted language. Finally, the word citation in parentheses, citation, tells us that there was a citation in the quote, but the court decided not to give us the citation. 19. The holding of the court, we hold that, is that Statute 1529 was impliedly amended to authorize service up to 10 p.m. A holding is also called the court's ruling. Courts do not always use the words hold or holding when stating their holding. Alternative language might be used, such as we conclude or therefore. 20. In Bruni, the consequences of the court's resolution of the issue are stated toward the very end of the opinion. The judgment of the lower court is reversed. The lower court cannot continue to suppress, i.e., important example, declare inadmissible the evidence seized at the 9:30 p.m. search. This is the disposition of the court. An appellate court could take a number of positions with respect to a lower court's decision. It could affirm the decision, meaning to accept and confirm the decision. It could reverse, vacate, or otherwise modify the decision in whole or in part. It could remand the case, send it back to the lower court with instructions on how to proceed, such as how to retry the case. 21. In theory, a judge must be very precise in defining the issue before the court and in resolving only that issue. The judge should not say more than must be said to decide the case. The theory, however, is sometimes not observed. This can make your job more difficult. You must wade through the language of the court to identify 1. The precise issues. 2. The key facts for those issues. 3. The holdings for each issue. And 4. The reasoning for each holding. The worst tangent that a judge can stray into is called dictum. Dictum is a judge's view of what the law is, or might be, on the facts that are not before the court. The plural of dictum is dicta. Judge Smith indicated that the result of the cases might be different if the warrant were not specific. Like, for example, if it did not name the individual to be searched or what the investigator was looking for. This was not the situation in Bruni. Therefore, Judge Smith's commentary or speculation is dictum. The statement is dictum because it covers facts that were not before the court. 22. On any court, there may be several judges. They do not always agree on what should be done. The majority controls. The majority consists of more than half of the judges who agree on the final result or judgment in the case, including the holdings and reasoning. In Bruni, Judge Smith wrote the majority opinion. A concurring opinion is one that votes for the result reached by the majority, but for different reasons. In Bruni, Judge Jones concurred but specified that he accepted only the result of Judge Smith's opinion. Normally, judges in such situations will write an opinion indicating their own point of view. Judge Jones did not choose to write an opinion. He simply let it be known that he did not necessarily agree with everything Judge Smith said. All he agreed with was the conclusion that the warrant was validly served. To reach this result, Judge Jones might have used different reasoning, relied on different opinions as precedent, and etc. If all the judges on the bench agree on the result and reasoning, the opinion is called a unanimous opinion. If a majority of the judges cannot agree, a plurality opinion might be written, which the largest number of judges, short or a majority, agree on the result and reasoning. Assume, for example, that there are 7 judges on the bench, 4 of whom cannot agree. If any 3 can agree, their opinion would be the plurality opinion. 23. A dissenting opinion disagrees with part or with all of the result and judgment in the opinion of the majority or of the plurality. Dissenting opinions are sometimes heated. Of course, the dissenter's opinion is not controlling. It is often valuable to read. However, in order to determine what the dissenter thinks that the majority or plurality decided, analyze this. Locate a copy of Bamberger v. Ohio State Lottery Commission, 115 Ohio APP 3D 391685 NE2D 577 1996. Identify all the parties of the case. Online exercise. Go to www.supremecourt.gov and locate a case with a dissenting opinion, unanimous opinion, per curiam opinion, and concurring opinion. Locate a case with a majority opinion and dissenting opinion. Use cases from the current or most recent session of the court. 8-8 Legal Analysis, Skills, Briefing an Opinion.
Briefing cases requires patience and skill. This is a vast difference between reading a newspaper account of a recent court opinion and reading the opinion itself. In fact, it is more accurate to say that you dissect an opinion than to say that you read it. In short, you brief the opinion. Exhibit 8-10 summarizes the 10 parts of a comprehensive brief of a court opinion. Exhibit 8-11 presents a brief of Bruni that conforms to the guidelines as set forth
in this chapter. Finally, Exhibit 8-12 is a shortened version of the brief, a thumbnail brief. Exhibit 8-10, 10 parts of a comprehensive brief of an opinion. The 10 parts of a comprehensive brief of a court opinion. Citation, parties, objectives of the parties, theories of the parties, history of the litigation, facts, issues, holdings, reasoning, disposition. Citation. Tell the reader where can the opinion be found. Provide a full citation to the opinion you are briefing. Include name of the parties, volume number of the reporter, abbreviation of the name of the reporter, page on which the opinion begins, date of decision, parallel cites if available. A parallel cite is an additional citation where you can find the same written material in the library or online. In Chapter 9, we will cover public domain citations. If the opinion you are briefing has a public domain site included as well. Parties. Who are the parties? Identify the lead parties, their relationship to each other, and their litigation status. Lead parties. If there are numerous parties on both sides of the litigation, include only the first named party on each side. This first party is called the lead party. Relationship to each other. Examples: landlord and tenant, buyer and seller, husband and wife, parent and child, government and accused. Think of the categories of the parties in relationship to each other. Litigation status. State the litigation status of the parties below. At the trial, when the case began, like for example, plaintiff, defendant, and then state their litigation status here in the opinion you are now reading and briefing, like for example, appellee or appellant. If you are briefing a trial court's opinion that has not been appealed, the litigation status will be their trial status, like for example, plaintiff, defendant. If there have been several appeals, give the litigation status at each appeal. Objectives of the parties. When the litigation began, what were the parties seeking? State the ultimate objectives of the parties in terms of the end result they want from the litigation. Examples: to convict someone of a crime, to avoid conviction, to force someone to pay for injuries suffered, to avoid paying for another's injuries, to get a job back. The objectives may not be explicitly stated in the opinion. If so, do your best to guess what the objectives were based on, what you are told in the opinion. At this point, do not focus on tactical or procedural objectives. Theories of the parties. What are the legal theories of the parties at each level of the litigation? By theory, we mean the rule on which a party is relying as its legal basis in the suit. As we saw earlier, the rule that is the legal theory for bringing a suit is called a cause of action. Here are some examples of the plaintiff's legal theory. The defendant has violated a statutory rule, like for example, the plaintiff sues the state for violating Statute 235 of the statutory code on who is entitled to a license. The defendant has violated a common rule, like for example, the plaintiff sues the defendant for committing negligence in an automobile collision. The defendant will also have a legal theory in response to the suit of the plaintiff. If the theory rule is not explicitly stated, do the best you can to figure out what it is. It may be a simple denial, which is the equivalent of saying that the facts do not support the plaintiff's theory, or the plaintiff's theory is defective. Examples: a denial that the defendant violated the rule asserted by the plaintiff, a claim that another rule justified what the defendant did, an assertion that it was the plaintiff who violated a rule, which the defendant now claims as the defendant's own cause of action, entitles the defendant to relief from the plaintiff. Briefly state what these theories have been at each stage in the litigation to date. If an administrative agency has acted on the case, state the specific legal theories used by the agency, like, for example, failure to comply with an administrative regulation, and by other party, like, for example, it did comply, or the regulation is invalid because it violates another rule. At the trial level of a civil case, name the cause of action, like, for example, negligence, breach of contract, violation of Statute 65, and the main defenses, like, for example, general denial or failure of plaintiff to prove unreasonable care. At the trial level of a criminal case, state what the prosecution was for, like, for example, murder, and the response of the defendant, like, for example, self-defense. An explicit or implied denial is the equivalent of saying that the facts do not support the plaintiff's legal theory. On appeal, briefly state the main legal theory of each party, like, for example, the trial judge applied the wrong law. Note that the rules stated in these legal theories do not include the holdings that will result from the opinion you are briefing. The holdings of the present proceeding will be stated elsewhere in the brief. For this section of the brief, theories of the parties, state the theory asserted at each stage of the prior proceedings, and also state the theory of the parties going into the present proceeding. History of the litigation. What has happened thus far in the litigation? The case may have already been heard by an administrative agency, by one or more trial courts, and by one or more appellate courts, before it reached the present proceeding that led to the opinion you are briefing. State the history of the litigation at two main stages. For each prior proceeding, briefly state the nature of the proceeding, who initiated it, the name of the court or agency involved, and what the court or agency did. For the present proceeding, briefly state the nature of the proceeding, who initiated it, and the name of the court or agency involved. The history of the litigation will contain procedural facts, which are the steps the parties took in every proceeding to date to get to the court that wrote the opinion you are briefing. You should also state what each lower court or agency did. You won't state what the present court did until you get the deposition. You won't state what the present court did until you get the disposition of the opinion you are briefing. Facts. What are the key facts? The court may give many background facts, but we want the key facts. This is one of the most significant parts of the brief. A key fact is a fact that was very important or essential to the result or holding in the court opinion you are briefing. You know you have identified a key fact if you can say that the holding would probably have been different if that fact had not been in the opinion. For each holding, identify the facts that were most important to the court. Note the facts that the court emphasized by repetition or by the use of adjectives, such as material or crucial. A court may provide hundreds of facts to give context to the opinion. Often, however, only a few of those facts are important or significant enough to have persuaded
the court to rule in a certain way. Proper names of parties or witnesses are rarely helpful in the statement of facts, but classifications or categories into which they fit are almost always helpful. If, for example, the opinion is about a purchase that Helen Olson made from Dayglow Supplies, it will probably be key to say that the opinion is about a purchase made by a buyer from a retail supplier. Don't confuse the facts of the opinion you are briefing with the facts and other opinions that the court cites. Note, however, that the way the court discusses the facts and these other opinions will often give you clues to what facts were key in the opinion you are briefing. Issues. What are the issues now before the court? Provide a comprehensive statement of each issue by quoting specific language of the rule in controversy, which would be one of the elements of that rule, the element in contention, plus several important facts that are relevant to this contention. The court may not use the word element, but when it quotes specific language from the rule in dispute, it will be giving you the elements in contention. The contention will be over the definition of the element, on whether the facts fit within the element, or on both the definition and whether the facts fit within it. Holdings. What are this court's answers to the issues? What are the holdings? If you have stated each issue comprehensively, its holding will be a simple yes or no response. Reasoning. Why did the court answer the issues the way it did? State the reasons for each holding. The reasons can be varied. Examples. The facts substantially support the conclusion that the legislature intended the statute to have the meaning stated in the holding because the conclusion is supported by precedent, namely the prior opinions of society would benefit because the statute was unconstitutional because the administrative regulation violates the statute because, etc. Disposition. What order did the court enter as a result of its holdings? State the disposition, i.e., for an example, the consequences of the court's resolution of the issues. Examples. The defendant must pay damages to the plaintiff. The lower court decision is reversed and a new trial is ordered. The case is remanded to the trial court in order to Exhibit 8-11, Comprehensive Brief of People v. Bruni. Keep in mind, as we examine the 10 components of a comprehensive brief, that not everyone agrees on what the components are, nor on what the components should be called. As with most aspects of the practice of law, you should expect to find diversity among your supervisors on how things are done. Nevertheless, at the core, you will find that the 10 components in Exhibit 8-10 are consistent with other briefing formats. 8-8A, pre-read before briefing. Here are some preliminary steps to follow when briefing. Skim the opinion a few times before starting to read it. Start taking short notes. Note any headings provided by the court. How a court divides an opinion can help you understand what it does. Note who the main parties are. This is usually indicated at the very beginning of the opinion. Note the general category into which the opinion fits. Is it a criminal case, an antitrust case, a negligence case? Note whether the court states the issues in the case early in the opinion.
Note who won, usually indicated at the end of the opinion. Occasionally, however, the court will summarize its main conclusion at the beginning of the opinion. If there was no clear winner, note what the court did to resolve the case, like, for example, send it back, remand it to a lower court for further proceedings. Now begin your first reading of the entire opinion. Start your brief with the second reading, assembling what you need in order to identify the 10 parts of a comprehensive brief outlined in the Exhibit 8-10. Have access to a paper, legal dictionary, or an online dictionary, like, for example, dictionary.law.com, in order to check the meaning of unfamiliar terms. Be cautious, however, in using a dictionary. It can be helpful in understanding common legal terms that the judge assumes the reader already knows, like, for example, the definition of motion. But a standard legal dictionary will not provide the ultimate answer to the legal issues before the court. Quick tip: the most widely used, cited, and accepted legal dictionary is Black's Law Dictionary. There are others, but Black's is the gold standard of legal dictionaries. That is one to use and cite when needing a legal definition. View the most recent edition when looking up definitions, which is available online or in a hardbound volume. 8-8B, additional notes for the brief. At the end of your brief, you should consider adding some notes that cover the following topics. What has happened to the opinion since it was decided? Has it been overruled? Has it been expanded or restricted by later opinions? You can find the later history of an opinion and its treatment by other courts by using citators such as Shepard's citations or key cite. See Chapter 9. Summary of concurring opinions, if any. Summary of dissenting opinions, if any. Interesting dicta, if any, in the majority opinion. Your own thoughts about the opinion. Was it correctly decided? Why or why not? Quick tip: try and keep your case briefs to 1 or 2 pages. You do not want to make your case brief longer than the actual case. There are exceptions, especially when the case is exceedingly long. Even in those instances, try and compress the information into a short yet comprehensive form. 8-8C, thumbnail brief. A thumbnail brief is, in effect, a brief of a brief. It is a shorthand version of a 10-part comprehensive brief. A thumbnail brief includes abbreviated versions of 6 of the components: citation, facts, issues, holdings, reasoning, and disposition, and leaves out 4 of the components: parties, objectives, theories, and history of the litigation. By definition, you must know how to do a comprehensive brief before you can do a shorthand one. Many students fall into the trap of doing only shorthand briefs. It takes considerable time to do a comprehensive brief. It is highly recommended, however, that early in your career you develop the habit and skill of preparing briefs comprehensively. Shorthand briefs are valuable time savers when communicating with colleagues, but they are not substitutes for comprehensive briefs. See Exhibit 8-12. Exhibit 8-12, thumbnail brief of People v. Bruni. Quick tip: oftentimes a court tells what its result is in plain language. Look for language such as "our holding is," or "the result of our decision is," or "we are of the opinion that."
These are magic words to look for in cases that will assist you in finding what the case stands for and what the holding of the case is, the rule of law that the case stands for. Social media. The legal blog, a place where individuals share information, is on a blog. The legal profession is no different. A blog is a web-based forum where anyone can share commentary or post material on virtually any subject, and others can provide comments in response to the blog. Legal blogs are a form of communication for legal professionals to showcase their expertise and discuss new cases, trends in the legal profession, and just about any legal-related topic imaginable. Blogs, as some may call them, is simply the slang for a legal blog. Many legal professionals blog, write about legal issues, and use it as a forum to exhibit their expertise in an area of law and comment on legal issues that may be of interest to them or others, or issues that are currently trending. There are thousands of legal blogs on every legal topic and issue, including blogs that are tailored for paralegal issues, such as blogs on finding a job, legal ethics, legal writing, and legal technology. Updates, to name a few. If you are looking for a blog to follow, do a search for the specific area you are seeking to follow and review the content to determine if it is a blog worth following. It should be noted that a legal blog should follow the general definition of a blog and not cross the line of a self-service advertising tool. A Virginia attorney had the Supreme Court of Virginia take note of advertising seemingly disguised as a blog. Hunter v. Virginia State Bar, EXREL, the 3rd District Committee, 285 VA 485 744 SE 2D 611 2013, examined whether the information that Hunter posted on his blog violated professional rules of conduct. The court opined that Hunter's blog really was advertising for him and his firm, and that at times could be misleading. Hunter argued that his blog was protected under the First Amendment and that he did not violate any rules of professional conduct. The Virginia Supreme Court, as in so many instances, raised concerns that the legal professional is under a different set of rules than others not regulated by state Supreme Courts and bars. Although many legal professionals use blogs, there are limitations that are imposed to protect the public from misleading information. Consequently, the court determined that the way to guard against misleading information required Hunter to post on his blog a very specific and detailed disclaimer based on the information that he was posting on the blog. This disclaimer that the court insisted be added to the blog was related to a rule of professional responsibility under the Virginia State Bar. What is interesting about the opinion is that there were dissents filed by 2 of the justices of that court. The end result is that blogs are a means of communicating legal information, but it must be done in accordance with the rules of professional responsibility. (8-9) Legal analysis skills. Applying an opinion. Applying a case. A court opinion means determining whether the ruling in the opinion, called a holding, applies to the facts presented by a client. In a classroom setting, applying a case means determining whether the holding applies to the facts of the hypothetical devised by the instructor. In the following discussion, we will refer to the client's facts or to the hypothetical facts as the problem facts and we will refer to the facts in the opinion as the case facts or simply as facts in the opinion. A court opinion can have two impacts. First, it resolves the legal dispute between the specific parties within the opinion. Their controversy is over. Under the doctrine of res judicata, they will not be allowed to relitigate any issue that was resolved on the merits. Second, the opinion might become a precedent for future cases. The rest of the world can read the opinion to assess whether its conclusions, holdings, can be applied to the legal disputes of others. Under the doctrine of stare decisis, similar cases should be decided the same way unless there is a good reason to reach a different decision. Hence, when a client walks into a law office and presents facts that raise legal issues, the office must determine whether any prior cases, opinions, are precedents for the client's case. The process of finding out is called applying court opinions, applying cases, or analogizing cases. The word analogy means a comparison of similarities and differences. To analogize a case is to determine whether it is sufficiently similar to the facts presented by a client, the problem facts, to justify a similar outcome or result. When we say that a case is analogous, we are saying that the holding in the case should apply to the client's facts because there is a sufficient similarity between the case and the problem facts to justify a similar outcome or result. To determine whether an opinion is analogous, we need to use two skills: rule comparison and fact comparison. 8-9A, rule comparison. Assume that your client in the problem facts is charged with failing to make estimated payments as required by Statute 23, which is an estate tax statute. Step 1 is to break the rule, Statute 23, into its elements and find the element in contention. The element in contention in this rule is the phrase estimated payments. In Statute 23, this becomes the basis of the issue. Step 2. After you have phrased the issue, is to do your own analysis based what you think each side would contend is the definition of estimated payments. Step 3 is to do some legal research on Statute 23. Here are some of the research steps you would take, not necessarily listed in the order in which you would take them. Find out if any other statutes help define the phrase. Check the legislative history of Statute 23 to see if it sheds any light on what the legislature intended by the phrase in Statute 23. Find out if there are any administrative regulations covering Statute 23. Find out if any court opinions have interpreted and applied Statute 23. Our concern here is the last step. We want to know if there are court opinions that have interpreted and applied Statute 23. You would not waste time looking for opinions that have interpreted other primary authorities such as housing or pollution rules. You focus on opinions that cover the same rule involved in the client's case. Statute 23. This is also true of common law rules. If, for example, the client has a negligence case involving an attractive nuisance, a rule covering the duty owed to children, you search for negligence opinions interpreting the attractive nuisance rule. Suppose, however, that you cannot find opinions interpreting the same rule.
Occasionally, you can use opinions applying different rules, but only if they are similar in language and purpose. In the tax example, the problem facts concerned the failure to pay. Estimated taxes under Statute 23 of the rules governing state taxes assume that you cannot find any opinions interpreting Statute 23, but that you can find an income tax opinion applying Statute 100, which also uses the phrase estimated taxes. Can you use such an opinion? Usually not. If, however, you carefully compare the language used in the two rules, Statute 23 and Statute 100, and the reason, purpose, or intent the legislature had in writing them, you may be able to argue that the opinion interpreting Statute 100 can be helpful in interpreting Statute 23. To be able to do so, the language and purpose of the two rules must be sufficiently similar. Assume further that our estate tax case arose in Maryland and that Statute 23 was written by the Maryland statute legislature. In our search for court opinions, we will look for opinions written by Maryland state courts, preferably the highest state court in Maryland. Such opinions are mandatory authority for all lower state courts in Maryland. If no such opinions exist, can we use opinions from other states that have the same or similar language as Statute 23 in Maryland? Possibly. There are times when opinions from other states or jurisdictions can be used as persuasive authority. For now, however, our focus is on court opinions from the same state. To summarize, follow these guidelines on rule comparison. Don't try to apply an opinion to problem facts unless the problem facts involve the same rule that was interpreted in the opinion. Also, concentrate on opinions decided by courts in the same jurisdiction where the problem facts will be litigated. Again, there can be exceptions to these guidelines, but use them as starting points. Let's review the case of Allen v. Amtrak 228F APPX 144 3D Circuit 2007. For a case where the plaintiff's attorney did not perform any legal analysis with less than desirable results for his clients, pay close attention to the concluding admonishment of the judge who authored the opinion. Order of the Court, a case study, Allen v. Amtrak, United States Court of Appeals for the Third Circuit, 228F APPX 144 3D Circuit 2007. Allen v. Amtrak 228F APPX 144 3D Circuit 2007 is a summary judgment case before the Third Circuit Court of Appeals with facts that are relatively straightforward. The case involves a claim by Amtrak employees of racial discrimination, hostile work environment, retaliation, and failure to promote, all allegedly in violation of Title VII of the Civil Rights Act of 1964. The employees hired an attorney who participated in discovery, including numerous depositions of the named employees of the case. Amtrak responded by showing that they immediately responded to any complaints and had policies in place to address the issues raised by the plaintiffs. What is important about this case is that the court was clear that the plaintiffs, and more specifically the attorney, did not adequately defend the claims of discrimination and did not show that they had a prima facie case against Amtrak of any of the claims alleged. The court detailed in its opinions the reason why it affirmed the summary judgment entered by the district court. What is important about the Allen case is what the attorney did not do in the case. What is important about the Allen case is what the attorney did not do in the case. Legal analysis. The last paragraph of the case should be a reminder to all of us should be a reminder to us all of the importance of doing the work when preparing and defending a case. The judge in Allen v. Amtrak made the following concluding remarks. In closing, we cannot help but note that the plaintiff's brief does not meet the rather basic requirements of Federal Rule of Appellate Procedure 28A9. It makes no attempt to set out the elements of the various Title VII claims. Indeed, it fails to cite a single case for a proposition relevant to Title VII. For all its rhetoric about summary judgment, it makes no attempt to connect the summary judgment standard to the substantive law applicable to this case, and it fails to cite the plaintiff's deposition, which are clearly relevant to whether they can provide evidentiary support for their claims. We note that counsel's performance in front of the district court was so underwhelming as the court sanctioned him for numerous discovery violations. In any future appearances before our court, we strongly advise plaintiffs' counsel to take notice that we expect more from members of our bar, ID at 150. The court's words are notable and a warning of the expected professional standards for those practicing in the legal profession. Discussion questions. Examine Allen v. Amtrak. What were the facts of the case? What allegations did the plaintiffs raise in the case? What are the elements of a summary judgment? Why did the court find in favor of Amtrak in the case? 8-9B Fact Comparison. Now we come to the critically important skill of fact comparison when trying to apply a court opinion. We are assuming that you have already done a rule comparison and are satisfied that the statute, common law rule, or other primary authority interpreted in the opinion is the same rule you are exploring for the problem facts. For example, your client has been charged with bigamy in the state of Georgia, and you are trying to apply an opinion of the Georgia Supreme Court on bigamy. You must now do a fact comparison in order to determine if the opinion applies to the problem facts. To determine if the opinion is analogous, when comparing facts in an opinion case, facts with problem facts. Follow these 3 steps. 1. Identify fact similarities, differences, and gaps. 2. Identify the key facts for a holding in the opinion. 3. Compare those key facts with the problem facts. 1. Identify factual similarities, differences, and gaps. Identify factual similarities, factual differences, and factual gaps between the facts in the opinion, case facts, and the problem facts. The heart of your analysis begins when you start comparing the facts in the opinion with the problem facts. Specifically, you need to identify factual similarities, factual differences, and factual gaps. The comparison should include individual facts and broader categories of individual facts. Don't worry at this point about whether any of these comparisons are significant. Many won't be. For now, however, concentrate on lining up all these similarities, differences, and gaps. Later, we will weed out what is irrelevant and focus on the comparisons that are significant. Example. The rule comparison for this example is easily stated. Our client is being sued for defamation in California. Bray Academy v. Davis is a California opinion that interprets the same rule, defamation. The next step is a fact comparison. As we list similarities, differences, and gaps, note that the comparisons often categorize individual facts.
For example, an individual fact in the client's case is that Dr. Orlife feared losing patients, and an individual fact in the opinion is that Bray Academy received calls from people who saw the Facebook statement and was concerned about a decline in future enrollment. The list below categorizes these individual facts by saying that both defamation plaintiffs were worried about their reputation. First, identify all factual similarities. Both Lang in our facts and Davis in the opinion are being sued for damaging or harming the reputation of the plaintiff. There was an economic fear in both controversies. Dr. Orlife feared the loss of patients, and Bray Academy feared the loss of future applications. A possible loss of revenue is involved in the dentist suit and in the school case. There is no indication that Orlife has actually lost any patients as a result of Lang's statement. Similarly, the opinion does not say that Bray Academy suffered any actual harm as a result to Davis's statement. The opinion does not say that applications have in fact declined as a result of the Facebook posts. The allegation of Lang concerns the safety of patients because fake diplomas suggest that Orlife does not have the skills to perform dentistry and therefore may harm the patients. The statement of Davis also concerns the safety of children being coached by people with criminal records. Next, identify all factual differences. Lang is being sued for an oral statement, what was said to another patient on the phone, whereas David was sued for a written statement, what was written on Facebook. The plaintiff Orlife, in our facts, is a person, whereas the plaintiff in the opinion is an institution, a school. The defendant in our facts made the statement to one person, Mary Adams, whereas the statement in the opinion was made online. Presumably to more than one person. Lang's statement involved a healthcare practitioner, a dentist, whereas Davis's statement involved sports and educational personnel. Next, identify all factual gaps, if any. In our facts, the defendant Lang had a prior association with the defendant. Adams was a former patient. Whereas in the opinion, we do not know if the defendant Davis is a current or former student of Bray Academy or has any other prior or current association with the academy. The recipient of Lang's statement in our facts, Mary Adams, has a current association with the plaintiff. Adams was the patient, whereas in the opinion we are not told if people who read the Facebook posts were current or former students at Bray's Academy, or if they had any other association with the academy. We know that Bray receives calls about the Facebook statement, but we are not told if any of the callers had any association with Bray. Again, don't worry about whether any similarities, differences, and gaps are significant. Your job at this stage is to push yourself to think of as many of these comparisons as you can. Let's look at another example. Example, your facts, problem facts. The rule comparison for this example is easily stated. Our client wants to bring a suit in Massachusetts for negligence alleging failure to use reasonable care. The same rule was applied in the Massachusetts case of Smith v. Apex Co. The next step is a fact comparison. Note the fact categorizations of individual facts in the following comparisons. First, identify all factual similarities. The client, Fox, was in a public place, a store. Smith was also in a public place, an office building. Both the store and the office building are commercial entities, businesses. Both situations involved some kind of warning, the danger sign and the wet floor sign. The warning in both situations was not conspicuous.
The danger sign was 3 inches. The wet floor sign was small. Next, identify all factual differences. Fox was in a store, whereas Smith was in an office building. The client's case involved a hole or pit, whereas Smith vs. Apex Co. involved a slippery surface. Fox was there about a possible purchase, whereas Smith was looking for directions and therefore was not trying to transact any business in the office building. Both the store and the office building were open to the public, therefore no indication that anyone was restricted from entering. There is no indication that anyone was restricted from entering. Next, identify factual gaps, if any. Smith saw the wet floor sign, but we do not know whether Fox saw the danger sign. 90% of your legal analysis is complete if you have been able to make these 3 categories of fact: comparison, factual similarities, factual differences, and factual gaps. Many students either ignore the categories or do a superficial job of laying them out. They do not carefully pick apart the facts in order to identify similarities, differences, and gaps. 2. Identify key facts in the opinion. Identify the key facts for each holding in the opinion you are applying. The next step is to focus on the key facts in the opinion. When you brief the opinion, you identify the key facts for each holding in the opinion. As we saw earlier, a key fact is one that was very important or essential to the holding or conclusion reached by the court. In a divorce opinion, for example, it probably will not be a key fact that the plaintiff was 33 years old. The court would have reached the same result if the plaintiff had been 32 or 34. Age may have been irrelevant or of very minor importance to the holding. What may have been key is that the wife postponed education in order to work so that their partner and spouse could complete their education. Without these facts, the court might not have reached the conclusion holding that the wife was entitled to a share in their partner's future earnings. In the property statement, carefully comb the opinion to read what the judge said about the various facts. Did the judge emphasize certain facts in the opinion? Repeat them. Label them as crucial or important. These are the kinds of questions you must ask yourself to determine which facts in the opinion were key. 3. Compare key facts in the opinion with the problem facts. Compare the key facts in the opinion with the problem facts. Compare the key facts in the opinion for each holding with the problem facts. Here are your objectives when comparing key facts with the problem facts. If you want a holding to apply to the problem facts, try to show that there is a substantial similarity between all the key facts in the opinion for that holding and the problem facts. If you do not want a holding to apply to the problem facts, try to show that there is a substantial difference between at least one of the key facts for that holding and the problem facts. If a holding in an opinion is favorable to your client in the problem facts and you want the holding to apply, you emphasize the similarities between the problem facts and all the key facts for that holding in the opinion. They must be substantially similar for the holding to apply. If any of your problem facts differ from a fact in the opinion, you try to point out that this is not significant because the latter was not a key fact in the opinion. If a holding in an opinion is not favorable to your client in the problem facts, and you do not want that holding to apply, you emphasize the differences between the problem facts and the key facts for that holding in the opinion. You need to show that there is a substantial difference between the problem facts and at least one key fact for that holding. This is known as distinguishing the case. By distinguishing a case fact from your set of facts, you can show
why that case holding or reasoning should not apply. If some of the problem facts are similar to a key fact in the opinion, you try to point out that this is not significant because there is still a dissimilarity with at least one key fact for that holding in the opinion. For a holding to apply, all its key facts must be substantially similar to the problem facts. When you want a holding to apply, the best opinion to find is one that is on all fours with the problem facts. Another term is to say that the case is on point. The facts in such an opinion are exactly the same as the problem facts, or almost so. Such opinions, however, are relatively rare. Most opinions will have a mixture of similar and dissimilar facts, requiring you to go through the kind of analysis described above. Handling fact gaps. If you can't fill a factual gap by obtaining more facts, do the best you can to assess its significance. If the factual gap is in the facts of your client's case, you simply go back to the client and ask them about the fact. In our negligence example, the paralegal asks the client, Ed Fox, whether they saw the danger sign. Suppose, however, that the factual gap is in the opinion itself. Assume that your client was running when they fell into the pit, but that the opinion does not tell you whether Tom Smith was running, walking, or etc. You obviously cannot go to Smith or to the judge who wrote the opinion and ask. You must make a guess of what the judge would have done in the opinion if Smith was running at the time they slipped on the corridor floor. You may decide that it would have changed the result, or that this additional fact would have made no difference to the holding of the court. Exhibit 8-13 summarizes the fact comparison steps we have been discussing. Exhibit 8-13. Fact comparison when applying opinions. 1. Identify factual similarities, factual differences, and factual gaps between the facts in the opinion and the problem facts. Compare both individual facts and broader categories of individual facts. 2. In the opinion, identify the holding and the key facts for that holding. If there is more than one holding in the opinion, do this for each holding that is relevant to the problem facts. 3. A holding cannot apply to problem facts unless all of the key facts for that holding are substantially similar to the problem facts. 4. Compare the key facts in the opinion with the problem facts. If you want a holding to apply to the problem facts, try to show a substantial similarity between all the key facts in the opinion for that holding and the problem facts. If you do not want a holding to apply to the problem facts, try to show that there is a substantial difference between at least one of the key facts for that holding and the problem facts. If you can't fill a factual gap, do the best you can to assess its significance. 8-9C, Memorandum of Law Applying an Opinion. One of the examples we just examined involved the application of the opinion Smith v. Apex Co. to the problem facts of Ed Fox. Let's look at how this application might look in a memorandum of law. See Exhibit 8-14. The client's case in the problem facts and the Smith opinion involve exactly the same rule. The common law duty of owners of commercial premises to use reasonable care to assure the safety of users of the premises. Assume that the element in contention in this rule is the requirement of reasonable care. The contention will be over whether the facts fit within the definition of the element of reasonable care. Exhibit 8-14. Example 3, Memorandum of Law using IFRAC as a guide. Office Memorandum of Law, June 30th, 2024. 2. James O'Toole, Esquire, Senior Associate Attorney. From Rachel Parker, Paralegal Supervisor. R.E. Whether the store owner, James Jackson, was negligent. Our case, Ed Fox v. James Jackson, Office File Number 24-3218. Kind of case, personal injury and negligence. Docket number, the case has not yet been filed. Introduction. This memorandum addresses the question of whether a store used reasonable care for the safety of its occupants, such as our client Ed Fox. My conclusion is that it did not. 2. Issue and summary conclusion. Issue. Is a store owner negligent for failure to use reasonable care towards someone who was injured by a pit in the store, when the only available warning was a small danger sign near the pit? Summary conclusion. Yes, reasonable care requires additional precautions because of the danger. 3. Facts. Ed Fox saw an ad in a newspaper announcing a sale at a local store in downtown Boston. He went to the back of the store and fell into a pit. The only warning in the area was a small 3-inch sign that said danger near the pit. Rule. Under the standard common law negligence rule, in this jurisdiction, owners of commercial premises must use reasonable care to assure the safety of users of the premises. Smith v. Apex, Co. 233 MASS 578-58878 Northeast 2D 422430 1980. Analysis. According to Smith v. Apex Co., there are 5 elements of the common law negligence rule on the premises liability of commercial owners. 1. Owners. 2. Of commercial premises. 3. Must use reasonable care. 4. Assure the safety. 5. Of users of the premises. The only element that the parties are likely to dispute is the third, on reasonable care. The parties will probably agree on the definition of reasonable care. Ordinary prudence under the circumstances to avoid injury or other loss, but disagree on whether the facts fit within the definition. An important opinion on reasonable care that is required of owners on premises is Smith v. Apex Co. (233) MASS 57878 NE 2D 422 1980. In this opinion, the holding of the court was that the owner of an office building was liable for negligence when Smith slipped on a wet corridor floor in the building. There was a small wet floor sign in the corridor. The opinion is substantially similar to our own client's case, but we're in the public buildings where owners can expect people to be present. In both situations, the warning was insufficient. The wet floor sign in the opinion was small. The danger sign in our situation was little. Because of these important similarities, it can be argued that the holding in Smith v. Apex Co. applies. The court in Smith emphasized the inconsistency of allowing an owner to invite the general public to visit its facilities, but to do little more than the bare minimum to provide for their safety. ID at 58278NE2D at 428. Reasonable care should have included additional safety measures such as a sign larger than 3 inches and a rope or other barrier around the pit. It is true that the opinion, the judge pointed out that Smith saw the sign. Our facts do not state whether the client saw the danger sign in the store. This, however, should not make any difference. The judge in the Smith opinion would probably have reached the same holding if Smith had not seen the wet floor sign. In fact, the case
would probably have been stronger for Smith. If he did not see the sign. The building was dangerous in spite of the fact that users of the building, such as Smith, could see the sign. Obviously, the danger would be considered even greater if such users could not see the sign. We should find out from our client whether he saw the danger sign, but I do not think that it will make any difference in the applicability of the holding in Smith v. Apex Co. The store owner will try to argue that the opinion does not apply. His argument might be that a pit is not as dangerous as a wet floor because a pit is more conspicuous than a wet floor and hence not as hazardous. A user is more likely to notice a hole in the floor than to notice whether a floor is slippery enough to fall on. Our client could respond to pointing out that the pit was in the back of the store, where it may not have been very noticeable. We need to check this and perhaps photograph the area. Furthermore, the wet floor in the opinion was apparently conspicuous. Smith saw the wet floor sign, yet the judge still found the defendant liable for the failure to provide reasonable care. Finally, Ed Fox is arguably in a better position than Tom Smith. James Jackson was explicitly inviting people like Ed Fox into his store by placing the ad in the paper for the sale to which Fox was responding. Tom Smith, on the other hand, was using the office building for his own purpose, to seek directions, yet the court still found that the office building failed to provide sufficient protection for Smith's safety. Surely, someone using a building to do business with the owner is entitled to the same, if not greater, protection than someone who is there for no purpose other than his own. Conclusion. Our client has the stronger argument on whether the store was negligent in failing to use reasonable care. Better warning should have been provided in view of the danger posed by the pit in the store. Note that the memo in Exhibit 8-14 builds on the skills we have been covering in this chapter. The rule is broken into elements. The element in contention is identified and an issue is based on this element. A definition of the element is stated here. The parties agree on the definition, but disagree on whether the facts fit within the definition. A court opinion is used to help determine how the definition applies. The structure of the memo follows IFRAC. Quick tip. A reality is that most cases you research will not have just one case that is on point. Those situations are few and far between. Most cases will involve extensive analysis of case precedents that build on a client's legal issues, real-world perspectives, on-the-job observations. Once again, we see how paralegals in the field relay their experiences from on the job. Here, a paralegal working in the construction law area shares what is done in preparing a case, including the legal analysis and formulation of the facts when addressing disputes in that discipline. Because of the complex factual issues that arise with construction disputes, paralegals are critical in identifying, organizing, preparing, and analyzing extensive, relevant factual information. In many cases, whether a party wins or loses depends on how effectively facts are developed from documents, depositions, interviews, and site inspections. Thus, a successful construction litigation team will generally include a paralegal skilled in organization and management of complex and voluminous facts. Construction litigation also provides paralegals with a very distinctive area for expertise and specialization. M.
Gowan, A Guide for Legal Assistance, 229, Practicing Law Institute. And in our next paralegal perspective, we have a paralegal showing that familiarity of the facts and analysis of a case can have positive results for a case. We see here how a paralegal's input in a case may have provided the critical information that was the winning point in a criminal matter. Attorney Kitty Polito says she and other lawyers at McClure and Kamen use the firm's sole paralegal not only to do investigations, but also to pick cases apart piece by piece. Polito credits paralegal Julianne Clapp with cracking the case of a client who was accused by a co-defendant of hitting the victim on the back of the head. At trial, the pathologist testified that the victim had been hit from left to right. Clapp passed a note to the attorneys pointing out that such a motion would have been a back-handed swing for their right-handed client. Thus, it was more likely that the co-defendant, who was left-handed, was the one who hit the victim. The defendant won. Brandt Paralegals' acceptance and utilization increasing in Indy's legal community. 1. The Indiana Lawyer 1. Chapter Review 8-10. Chapter Summary. Legal Analysis Skills Introduction. 1. Legal analysis is the application of one or more rules to the facts of a client's case in order to answer a legal question that will help. 1. Avoid a legal dispute. 2. Resolve a legal dispute that has arisen. Or 3. Prevent a legal dispute from becoming worse. 2. Competent legal analysis requires a number of basic skills. Legal research, element identification, identifying issues, phrasing issues, defining important language, applying definitions, factor analysis, briefing court opinions, and applying court opinions. The most frequently applied rules in legal analysis are statutes, administrative regulations, common law rules, and constitutional provisions. Legal analysis skills, element identification. 1. An element is a portion of a rule that is a precondition to the applicability of the entire rule. Rules can have different consequences, such as authorizing or prohibiting something, requiring payments, and declaring definitions. Element identification requires you to list every portion of the rule that must apply in order for the consequence of the rule to apply. 2. The word "and" in a rule usually indicates separate elements of the rule. The word "or" usually indicates alternative options for the same element. 3. In identifying elements, know the consequence of the rules that apply to the facts of your situation. Stay away from listing the consequence as one of the elements. Use the exact word from the rule. Don't paraphrase, but you can make adjustments for clarity. 4. If a rule contains exception clauses, those should be noted in your elements. When a statute is long and is multi-layered, break down each subsection into elements. 5. Element identification is useful in drafting documents such as complaints or a memorandum of law. Additionally, element identification is helpful when organizing a client interview or investigation. It is also helpful in litigation, such as preparing defenses in a case or preparing for a deposition. Legal analysis skills, issue spotting, and phrasing. 1. An issue is a question that needs to be answered or resolved. Factual issues pose questions of what happened. Legal issues are raised when we want to know what the law is, what the law means, or how the law applies to specific facts. 2. It is important to identify within the issue the elements in contention. Those issues in contention are usually elements in dispute where both parties are in disagreement as to an element in contention, such as the definition or particular facts. 3. In the beginning, a shorthand statement of issues may be presented. As more facts are revealed, a more comprehensive statement of the issue or issues will be developed. 4. There are different ways to phrase the issue. A. State the element in contention before the relevant facts. B. State the relevant facts before the element in contention. C. Begin by stating the nation of the action. D. Use a whether and when sentence. Legal analysis skills definitions. 1. An element in contention is the portion of a rule about which the parties cannot agree. The disagreement may be over the definition of the element, whether the facts fit within the element, or both. Each element in contention is the basis of an issue. 2. The two components of a comprehensive statement of a legal issue are a brief quote from the element in contention and several of the important facts that are relevant to that contention. The element in contention often contains language that must be defined. The parties may disagree on whether this language should be defined broadly and narrowly. 3. To determine a definition, legal research may be required, such as finding the statutory or administrative definition of the word or concept in contention. Checking a statute or administrative rule is not the end of the analysis. Court opinions often set forth interpretations of legal definitions that must be followed. Legal analysis skills. Factor analysis. A factor is one of the circumstances or considerations that will be weighted in deciding whether an element applies. All factors must be analyzed to determine what applies to the facts of the case or not. Memorandum of law. 1. A memorandum of law may have different meanings. It may be an internal document or external document that may be presented to a court in support of a position in a case. 2. A guideline that assists in organizing a memorandum of law is IRAC. IRAC and IFRAC are acronyms that help you organize your legal analysis. IFRAC stands for Issue I, Facts, F, Rule R, Application to the Rule to the Facts, A, and Conclusion, C. 3. A memorandum of law has multiple parts, which generally consists of heading, introduction, issue, and summary conclusion, facts, rules, application, also called analysis, and discussion, conclusion, recommendations, and appendix. Each part is an important component of your analysis of the law and facts of a particular case. Introduction to court opinions. 1. Opinion, also called a case, is a court's written explanation of how it applied the law to the facts to resolve a legal dispute. Primary authorities often applied in opinions include statutes, administrative regulations, common law rules, and constitutional provisions. 2. There are different meanings for the word brief. A brief can be a case brief, a trial brief, or an appellate brief. A case brief may have as many as 10 components. The 10 parts of a case brief are citation, parties, objectives of parties, theories of the litigation, history of the litigation, facts, issues, holdings, reasoning, and disposition. A thumbnail brief often has only 6 of these parts, depending on the requirements of the assignment. 3. One of the most important parts of a case brief and court opinion is the holding. A holding is the court's answer to an issue. The holding becomes a new rule. The opinion can then become a precedent for future opinions. 4. Terms you need to understand when reading opinions include reporter, citation, appellant, plaintiff, defendant, respondent, syllabus, head note, key number, reasoning, remand, majority opinion, concurring opinion, etc. Learn the terms of law cited in a legal opinion for a comprehensive understanding of what the word is conveying to the reader. Legal analysis skills. Briefing an opinion. 1. Before briefing an opinion, skim the opinion to gain a better understanding of the case, the law, and its facts. Then read the opinion for a more detailed review of the case. Read the opinion a second time and begin crafting your case brief. It is always helpful to have a legal dictionary available. 2. The general parts of a case brief are citation, parties, objectives of the parties, theories of the parties, history of the litigation, facts of the case, issues presented to the court for review and determination, the holding of the case, what the case stands for, the reasoning of the case, the application of the law to the facts, and why the court ruled as it did. J. The disposition, the order of the court as a result of the holding. 3. A thumbnail brief is a shortened version of a brief. It is a brief of the brief. It usually highlights the main points of a case brief without the detail. Legal analysis skills. Applying an opinion. 1. A court opinion resolves a legal dispute between the specific parties within the opinion and might become a precedent for the future cases. To be a precedent, the opinion must be analogous. To determine whether an opinion is analogous, we need to make two comparisons, rule comparison and fact comparison. 2. First, you compare the rule, like for example, a statute or common law rule that was interpreted in the opinion, with the rule you are considering in the client's case. With limited exceptions, the opinion cannot apply unless these two rules are the same. 3. Second, you compare the key facts of a holding in the opinion with the problem facts, the facts of the client's case. If you want a holding to apply to the problem facts, try to show that there is a substantial similarity between all the key facts in the opinion for that holding and the problem facts. If you do not want a holding to apply to the problem facts, try to show that there is a substantial difference between at least one of the key facts for that holding and the problem facts. Chapter Review 8-10B Key Terms. Legal analysis, cause of action, elements, issue, legal issue, verdict, judgment, bench, trial, element and contention, habeas corpus, factor, dispositive, memorandum, memorandum of law, IRAC, IFRAC, docket number, RE, roadmap, paragraph, counter-analysis, stop, opinion, case, case books, brief, trial brief, holding, reporter, unofficial reporter, official reporter, citation, parallel cite, public domain citation, appellant, plaintiff, defendant, appellee, respondent, citators, syllabus, head notes, key number, digest, Westlaw, per curiam opinion, memorandum, opinions, key fact, reasoning, disposition, affirm, vacate, remand, dictum, majority opinion, concurring opinion, unanimous opinion, plurality opinion, dissenting opinion, hypothetical, res judicata, on the merits, analogous, mandatory authority, persuasive authority, on all fours. Chapter Review 8-10C Review Questions. 1. What is legal analysis and why should paralegals study legal analysis? 2. What is the relationship between the elements of a rule and the consequences of the rule? 3. How are and items treated in element identification? How are or items treated? 4. What is an issue and how does a factual issue differ from a legal issue? 5. What is an element in contention and what is its relationship to issues? 6. What are two components of a comprehensive statement of a legal issue? 7. What is IFRAC and how can it be helpful? 8. Name 9 parts that a memorandum of law can have. 9. What is an opinion? 10. What are the components of a case and define each? 11. What is a reporter and how does an official reporter differ from an unofficial one? 12. What are the 10 parts of the brief of a court opinion? 13. What are the 6 parts of a thumbnail brief?
14. What are the three components of fact comparison? 15. What fact arguments does an advocate make if they want a holding to apply? What facts arguments does an advocate make if they do not want a holding to apply? Chapter Review 8-10D Assignments Critical Analysis 8.1 Identify the elements of the following rules. A. Statute 200. Parties to a child custody dispute shall attempt mediation before seeking a custody order from the court. B. Statute 75B. Lawyers shall not enter into a business transaction with a client if they have differing interests therein, and if the client expects the lawyer to exercise their professional judgment therein for the protection of the client. C. Statute 38. A person or agency suing or being sued in an official public capacity is not required to execute a bond as a condition for relief under this section unless required by the court in its discretion. D. Statute 1.2. A lawyer may not permit a paralegal to represent a client in litigation or other adversary proceedings or to perform otherwise prohibited functions unless authorized by statute, court rule or decision, administrative rule or regulation, or customary practice. 8.2. Provide a shorthand and a comprehensive phrasing of the legal issue or issues in each of the following situations. A. Facts. Tom owns a 2019 Ford. One day, it stalls on a hill. The engine stops running. Tom wants to get the car off the street and pushes the car so that it glides off the street and onto the sidewalk. While Tom is pushing the car on the sidewalk, a police officer stops them. Statute 92B. The operator of any vehicle riding on a sidewalk shall be fined $100. B. Facts. Harry Franklin works for the XYZ agency. In one of the agency's personnel files is a notation that Paul Drake, another agency employee, was once arrested for fraud. Harry obtains this information from this file and tells their spouse about it, who also knows Paul. Harry is unaware that Paul has told at least 3 other employees about their fraud arrest. Regulation 20D. It shall be unlawful for any employee of the XYZ agency to divulge confidential material in any file of the agency. See facts. Jones has a swimming pool in their backyard. The pool is intended for use by the Jones family and guests who are present when an adult is there to supervise. One hot summer night, a neighbor's child opens an unlocked door of a fence that surrounds the Jones yard and goes into the pool. There is no separate fence around the pool. The child knows that they should not be there without an adult. No one else is at the pool. The child drowns. Statute 77. Property owners are liable for the foreseeable harm that occurs on their property. D. Facts. Dr. Carla Jones is the family physician of the Richardson family. After an appointment with Mary Richardson, age 16, Dr. Jones prescribes birth control pills. Mary tells Dr. Jones that they can't afford the pills and does not want their parents to know they are taking them. Dr. Jones says they will give them a supply of the pills at no cost in exchange for an afternoon of office clerical work at Dr. Jones's office. Statute 12C. It is illegal to sell prescription drugs to a minor. E. Facts. Victor and Kathy Mosley own a lingerie store called Victor's Little Secret in a small town in Kentucky. The multinational company, Victoria's Secret, objects to the name of this store on the ground that it can confuse the public and thereby dilute the value of its well-known mark. A mark is any language or symbols used to identify or distinguish one's product or service. Statute 43. The owner of a famous mark shall be entitled to an injunction for its dilution. 8.3. In each of the following problems, identify any ambiguous language and elements in contention. Give broad and narrow definitions of this language and state which side would argue which definition. Do not do any legal research. A. Facts. Alice Anderson is 9 months pregnant. A police officer gives them a ticket for driving in a carpool lane in violation of Statute 101. The officer said they gave Alice the ticket because they were alone in the car at the time. Regulation Statute 101. Carpool lanes can be used only by cars and only when there is at least one passenger with the driver. B. Facts. Mary is arrested for violating Statute 55 and is charged as a felon. Mary forced open the lock on the driver's side of the van at 5 p.m. Mary didn't know that the door on the passenger side was unlocked. They went into the back of the van and fell asleep on the floor. The police arrested Mary after waking them up at 9 p.m. The owner of the van claims that a $20 bill is missing. Mary had a $20 bill, but said it was their own. Statute 55. A person who breaks and enters a dwelling at night for the purpose of stealing property therein shall be charged as a felon. 8.4. Section 100 provides as follows. Motorists shall be liable for the foreseeable harm or damage caused by their driving. To determine foreseeability, the court must consider road conditions, speed, weather, visibility, and any other circumstance that would affect the likelihood of the harm or damage occurring. Charles Wilson ran their truck into the side of a parked car when they came to an abrupt stop at an intersection. There was some oil on the road. Wilson's truck skidded on the oil when they tried to stop at the intersection. The incident occurred at 7 p.m., just after rush hour. Was the damage caused by Wilson foreseeable? Do a factor analysis on the applicability of Statute 100. In your analysis, identify further facts that you would need to investigate. State how such facts might be relevant to your factor analysis. If there are unknown facts that you need, state what they are and the factors to which they are or might be relevant. 8.5. Prepare a comprehensive and a thumbnail brief of each of the following opinions. A. Seraphin v. Commonwealth of Virginia 288 VA 320 764 SE2D 71 2014. To read the opinion online, go to scholar.google.com, select case law, and type the citation in the opinion or type in the name of the case in Google. B. In Google Scholar, select case law and perform the following search: AABB, substituting your state for AA. And a legal topic that interests you for BB. Example, Florida capital punishment. Find a court opinion written by a state court in your state on your topic. Pick an opinion that is under 10 pages. C. Brown v. Hammond, printed in Chapter 6. 8.6. Read the following facts, taken from an opinion. Then read a quote by the judge who wrote this opinion. What is dictum in this quote and why? Facts. In the opinion, plaintiff sues a cable company for an injury to his foot allegedly caused by a hole the company left in the sidewalk. He claims that it was dark out at the time and that he was unconscious after he fell. When he woke up, he saw the hole. His leg was twisted and he saw that his sneaker had came off. The company asked the court to dismiss the complaint because the plaintiff had failed to produce enough evidence of where he fell and what caused the fall. Quote of judge writing this opinion: the cable company's position lacks merit. It is true that negligence claims will be dismissed if causation is based on pure speculation. In this case, however, plaintiff did in fact identify the cause and location of his accident. While he could not recall the exact manner in which his foot became entrapped in the alleged defect and could not describe the way it looked on the night of the accident prior to his fall, he repeatedly identified the hole between the sidewalk and depressed cable vault cover as the condition that trapped his foot and caused him to fall. Plaintiff also specifically identified by circling and initialing on a photographic exhibit the exact location and condition that caused his fall. The company's position would have merit if the accident had been caused by a transitory condition such as ice or a slippery liquid of nebulous nature. Here, however, plaintiff woke up with his leg twisted, then saw the hole, and even saw his sneaker was off. 8.7 and the following situations point out all factual similarities, differences, and gaps between the client's facts and the facts of the opinion. Do not analyze the law of negligence in A or the law of neglect in B. Focus solely on factual similarities, differences, and gaps. A. Client's facts. Jim is driving his car 30 miles per hour on a dirt road at night. He suddenly sneezes and jerks the steering wheel slightly, causing the car to move to the right and run into Bill's fence. Bill sues Jim for the negligence. Opinion: a pedestrian brings a negligence action against Mary. Mary is driving her motorcycle on a clear day. A page of a newspaper unexpectedly flies into Mary's face. Because she cannot see where she is going, she runs into a pedestrian crossing the street. The court finds for Mary, ruling that she did not act unreasonably in causing the accident. B. Client facts. Helen is the mother of David, age 4. The state is trying to take David away from Helen on the ground that Helen has neglected David. Helen lives alone with David, works part-time, and leaves David with a neighbor. Helen's job occasionally requires travel. Once she was away for a month. During this period, David was sometimes left alone because the neighbor had to spend several days at the hospital. When David was discovered alone, the state began proceedings to remove David from Helen on the ground of neglect. Opinion: the state charged Bob Thompson with the neglect of his twins aged 10. The state wishes to place the twins in a foster home. Bob is partially blind. One day he accidentally tripped and fell on one of the twins, causing severe injuries to the child. Bob lives alone with the twins, but refuses to hire anyone to help him run the home. The court ruled that Bob did not neglect his children. Projects 8.8. Determine the federal appeals district your state is in, such as the 1st, 2nd, 3rd, for example. Go to the appeals court website and locate presidential opinions from the last 30 days. Choose an opinion and identify the panel that heard the decision and the author of the opinion. Was it a unanimous opinion? Find a copy of the appellate briefs of the case you chose and identify the issues from both the appellant and appellee. What are the differences in the way the parties phrased the issues? What are the components of the appellate briefs and how do they differ from a memorandum of law. Chapter Review 8-10E Core Skills Assignments, Core Skill Writing. 8.9 The Pepsi-Cola Bottling Company is authorized to do business in Florida. It wishes to prevent another Florida company from calling itself the Pepsi Catsup Company because this name violates Statute 225.25. The Pepsi Catsup Company denies that its name is in violation of this statute. The Secretary of State has a responsibility of enforcing the statute. 48 State Code ANN, Statute 225.25, 1999. The name of a company or corporation shall be such as will distinguish it from any other company or corporation doing business in Florida. Your supervisor asks you to prepare a memorandum of law on the applicability of this statute. The office represents the Pepsi Catsup Company. Analyze the language of the statute 225.25 in a manner similar to the analysis of the Statute 17 in the sample office memorandum of law in Exhibit 8-7. Do no legal research at this time, although you should point out what research might be helpful. After you complete the memo, draft a letter to the Secretary of State giving the position of your office on the applicability of the statute. You can make up the names and addresses of the people involved, as well as any dates that you need. For guidance in composing the letter, see Exhibit 8-8. 8.10 Anthony Bay is a paralegal who works for Iverson, Kelly, and Winters in Philadelphia. Bay is an at-will employee. The supervising attorney is Grace Swenson. One day, Bay notices that Swenson deposited a client settlement check in the general law firm account. Bay calls the Bar Association Disciplinary Committee and charges Swenson with commingling funds unethically. Bay is fired for disloyalty. In the meantime, the bar investigates the charge of commingling and finds that the charge is accurate. Swenson is eventually disciplined. Attorneys have an ethical obligation to keep client funds and general law firm funds in separate accounts. Commingling or mixing these funds in one account is unethical, as we saw in Chapter 6. Can Bay sue Swenson and Iverson, Kelly, and Winters for wrongful dismissal? Write a memorandum of law that applies Brown v. Hammond to answer this question. Do not do any additional legal research. Use the memo in Exhibit 8-14 as a guide. The text of the Brown opinion is in Chapter 6. Core Skill Research 8.11 In a search engine of your choice, locate the different sites that have court opinions available for review. As a guide, enter Serafin v. Commonwealth of Virginia and list the online sites that reference the opinion. Core Skill Ethics 8.12 Frank Adams is a paralegal in the one attorney office of Jolene Richards, Esquire. Adams has paralegal, secretarial, accounting, and receptionist duties. Richards has one account in a local bank, Heritage Savings. Richards has authorized Frank to make deposits and withdrawals from the account. Frank's paycheck is a check drawn on the account at the bank. Richards has several personal injury cases. When a case settles, the insurance company sends Richard a check. The check is endorsed and instructs Frank to deposit it in the Heritage account. After deducting their fee, Richards will write a Heritage check for the balance payable to the client. Discuss ethical problems, if any, with this arrangement. Core Skill Computers 8.13 Creating Templates Standardized Forms For the preparation of many typically used documents is an important computer skill to master. Search how to prepare a template online. Prepare a template for the following documents. 1. Memorandum of law. 2. Case brief. From your search on how to create a template, add any new computer terminology to your CTL notebook you started in Chapter 1. Save your templates to your portfolio binder. Core skill collaboration 8.14. In this chapter on legal analysis, we covered how to brief an opinion. Exchange your case brief in Serafin v. Commonwealth of Virginia with another student and compare and discuss each section of the case brief. Discuss the similarities and differences between the case briefs. What were the differences in the briefs and why? Create a composite case brief between yourself and your classmate. Focus on the choices made and determine what to keep in, edit out, and change for a comprehensive document. The job search 8.15. Use the job links in Chapter 2 to find a job opening for an entry-level paralegal in a corporation in your state. What does the job entail, and what are these qualifications for the position? Give the website where you found this information. If no openings exist in your state, look for the position in any state. Chapter Review 8-10F Portfolio Binder Assignment 1. Your attorney has provided you with the case of Port Hamilton, Refin and TRA NSP LLLP v. United States EPA 2023 USAPP Lexus 1886787 F 4th 188 3D Circuit 2023. Based on the facts at the beginning of the chapter, how does this case apply, if at all? What additional facts would be needed to determine its applicability? What statutory section is discussed in this section? 2. Prepare a brief of the case for your attorney's review. Be sure you include a recommendation at the end of your brief. Place your case brief in your portfolio binder, along with a copy of the case itself for reference.